streaming service platforms, or YouTube, TikTok, X. I think they all hit about the same time. Today, we're getting right back into the Clarence Thomas hearings. They've been good. They've been good. Took a little break last night to listen to Elon and Trump. They talked about the assassination attempt. They talked about energy, drill baby drill. They talked about the world stage, and they talked about foreign entities trying to censor Americans here in America. It happens every day. And well, what do you think? What do you think about that? Let me know in the chat. Foreign entities censoring Americans here in America about American issues, or issues that also affect us here in America. Let's go ahead
on family.
And that's a brief look at some upcoming program highlights.
That's a brief look.
We begin now with today's confirmation hearing with the Senate Judiciary Committee.
Speaking into it by myself, just saying how the background is. It just sounds like the South Park rabble whenever there's a whole crowd of people and they're all rabble. Oh man, Joe Biden looked old in 1991.
That we'll have pleasure to have you back. Let me very briefly explain to you, your family, and everyone else the process this morning. I expect that we'll have 4 senators question before we break for lunch. And were I you, I'd probably want to break after 2, but it's up to you. I'll go through 4 senators until lunchtime unless there's some indication from you or anyone else that you'd like to stop, take a break for any reason at all, including getting a cup of coffee or anything else you want. Now, we will start today. Do you have a preference, Judge, is how you'd like to proceed? Really? I'm not kidding. Any way you want to do it.
We'll play it by ear.
Play it by ear. I agree with you. All right. Now, we will start this morning's questioning on the same basis, 1/2 hour opportunity for each senator to question, you to answer. And we'll start this morning with Senator Metzenbaum. I might add again, because we're asked by the press and others, we do not plan on going beyond 5 o'clock today, unless we're very close. I mean, but we're going to shoot for 4 or 5 o'clock for this hearing to end today, and we'll pick up tomorrow at 10 o'clock. We'll pick up tomorrow at 10 o'clock no matter what, depending on whether we still have questions, and I expect we will for the judge if people haven't had their second round. With that, let me yield the floor to Senator Metzenbaum.
Thank you, Mr. Chairman. Morning, Judge Thomas. It's nice to see you again. You have an extensive record of speeches and published articles. Judge, I have made no secret of the fact that I have serious concerns with many of the things in your record. Yesterday, I thought we would finally get some answers about your views. Instead of explaining your views, though, you actually ran from them and disavowed them. Now, in a 1989 article in the Harvard Journal of Law and Public Policy, you wrote, quote, "The higher law background of the American Constitution, whether explicitly appealed to or not, provides the only firm basis for a just, wise, and constitutional decision. Judge, you emphasize the word constitutional by placing it in italics. By that emphasis, you made it very clear you were talking about the use of higher law in constitutional decisions. But yesterday you said, I don't see a role for the use of natural law in constitutional adjudication. My interest was purely in the context of political theory, end of quote. Then in 1987, in a speech to the ABA, you said economic rights are as protected as any other rights in the Constitution. But yesterday you said the Supreme Court cases that decided that economic rights have lesser protection were correctly decided. In 1987, in a speech at the Heritage Foundation, you said Louis Lehrman's diatribe against the right to choose was a splendid example of applying natural law to choose. But yesterday you said, I disagree with the article, and I did not endorse it before. In 1986, you signed on to a White House working group report that criticized as fatally flawed a whole line of cases concerned with the right to privacy. But yesterday you said you never read the controversial and highly publicized report, and that you believe the Constitution protects the very right the report criticizes. In all of your 150-plus speeches and dozens of articles, your only reference to a right to privacy was to criticize a constitutional argument in support of that right. Yesterday you said there is a right to privacy. And Judge Thomas, I'm frank to say to you, I want to be fair in arriving at a conclusion. And I feel that I speak for every member of this committee who wants to be fair. Our only way to judge you is by looking at your past statements and your record. And I'll be frank, your complete repudiation of your past record makes our job very difficult. We don't know if the Judge Thomas who has been speaking and writing throughout his adult life is the same man up for confirmation before us today. And I must tell you, it gives me a great deal of concern. For example, yesterday, in response to a question from Senator Biden, you said that you support a right to privacy. Frankly, I was surprised to hear you say that. I've not been able to find anything in your many speeches or articles to suggest that you support a right to privacy. Unfortunately, the committee has learned the hard way that a Supreme Court nominee's support for the right to privacy doesn't automatically mean that he or she supports that fundamental right when it involves a woman's right to abortion. At his confirmation hearing, Judge Kennedy told us he supported the right to privacy. Since he joined the court, Justice Kennedy has twice voted with Chief Justice Rehnquist in cases that have restricted the right to abortion. Likewise, Justice Souter told us that he supported the right to privacy, and then when he joined the court, Justice Souter voted with the majority in Russ v. Sullivan. My concern is this, and I know I've been rather lengthy in this first question. Your statement yesterday in support of the right to privacy does not tell us anything about whether you believe that the Constitution protects a woman's right to choose to terminate her pregnancy. I fear that you, like other nominees before the committee, could assure us that you support a fundamental right to privacy, but it could also decline to find that a woman's right to choose is protected by the Constitution. And if that happens, soon there could be nowhere for many women to go for a safe and legal abortion. I must ask you to tell us here and now whether you believe that the Constitution protects a woman's right to choose to terminate her pregnancy, and I am not asking you as to how you would vote in connection with any case before the court.
Senator, I'd like to respond to your opening question first. And if you think it appropriate, to consider each of your questions seriatim. Yesterday, as I spoke about the framers in our Constitution and the higher law background, and it is background, is that our framers had a view of the world. They subscribed to the notion of natural law, certainly the framers of 13th, 14th Amendment. My point has been that the framers then reduced to positive law in the Constitution aspects of life, principles that they believed in, for example, liberty. But when it's in the Constitution, it's not a natural right, it is a constitutional right. And that is the important point. But to understand what the framers meant and what they were trying to do, it is important to go back and attempt to understand what they believed, just as we do when we attempt to interpret a statute that's drafted by this body to get your understanding. But in constitutional analysis and methodology, as I indicated in my confirmation to the Court of Appeals, there isn't any direct reference to natural law. The reference is to the Constitution and to using the methods of constitutional adjudication that have been traditionally used. You don't refer to natural law or any other law beyond that document. What I've attempted to do, and with respect to my answers yesterday, is to be as fair and as open and as candid as I possibly can. I have not spoken on issues such as natural law since my tenure as chairman of EEOC. At that time, it was important to me, it was very important, to find some way to have a common ground underlying our regime and our country on the issue of civil rights. I thought it was a legitimate ground. I wondered, I looked back at Lincoln, saw him here in Washington, D.C., surrounded by a pro-slave state, yet pro-union, and a Confederate state, and asked myself, what was it that sustained him in his view that slavery was wrong? And it was through that progress that I came upon the central notion of our regime, all men are created equal, as a basis or as one aspect of trying to fight a battle to bring something positive and aggressive to civil rights enforcement. And I thought it was a legitimate endeavor. At no time did I feel, nor do I feel now, that natural law is anything more than the background to our Constitution. It's not a method of interpreting or a method of adjudicating in the constitutional law area. With respect to your last question, and I assume for the moment that perhaps you don't want me to address each of the underlying questions or specific questions seriatim, I would say this about them, though. I have written and I have been interviewed quite a bit. I've been candid over my career. My wife said to me that to the extent that Justice Souter was a stealth nominee, I am Bigfoot. And I've tried to think through difficult issues without dodging them. As a judge, though, on the issue of natural law, I've not spoken nor applied that. What I've tried to do is to look at cases, to understand the argument, and to apply the traditional methods of constitutional adjudication as well as statutory construction. I am afraid, though, on your final question, Senator, that it is important for any of us who are judges in areas that are very deeply contested, in areas where I think we all understand and are sensitive to both sides of a very difficult debate, that for a judge, and as I said yesterday, for us who are judges, we have to look ourselves in the mirror and say, are we impartial or will we be perceived to be impartial? I think that to take a position would undermine my ability to be impartial. And I have attempted to avoid that in all areas of my life after I became a judge. And I think it's important. I can assure you, and I understand your concern, that people come here and they might tell you A and then do B. But I have no agenda. I have tried to wrestle with every difficult case that has come before me. I don't have an ideology to take to the court to do all sorts of things. I'm there to take the cases that come before me and to do the fairest, most open-minded, decent job that I can as a judge. And I'm afraid that to begin to answer questions about what my specific position is in these contested areas would greatly or leave the impression that I've prejudged this issue.
So this is the hearing, day 2, part 1, which is, we did cover that, and I wanted to get back to where we're supposed to be, which...
The committee will resume now.
Hear it.
Our judge, I didn't give you a chance to say anything. Did you want to say anything after my little discussion with the senator? I'm not asking you to, but did you?
Oh, Senator, the one point, and perhaps it's one that you probably already knew, I did not consider you a detractor of me. I think that the dialogue on natural law is an important one, and it's one that, of course, you indicated we would have, and I welcome the opportunity to explain
I
to
want to
you.
make clear also, I didn't think you did think I was a detractor, and I'm sure that Senator Simpson's not, but all kidding aside, that was really a discussion between Senator Simpson and me on whether or not this issue is of consequence. But thank you, and let me now yield to the senator from Arizona, Senator DeConcini.
Thank you very much. And members of the committee and Judge Thomas, I regret that I was unable to be here yesterday for the opening testimony, and I did read your statement and heard a lot about it. And indeed, it was a moving statement, and I compliment you for that candidness and openness. As co-chairman of the Helsinki Commission, I had to attend, or felt I had to attend, the opening of the International Human Rights Conference in Moscow prior to being here today. Our delegation, we traveled to the Baltic states and several other republics and had a interesting opening session in Moscow. And as I was traveling through these republics and listening to Gorbachev and others make speeches about human rights in Moscow, I couldn't help but think about the process that we are going through here today. The fundamental rights, the freedoms which the Americans have enjoyed for 200 years are just now coming to pass, perhaps, in the Soviet Union. My thoughts kept returning to these hearings and the founding fathers of how they struggled with this and didn't do a perfect job. It took a long time before we finally did some of the things we should have done earlier on. So our Constitution, which these small Democrats were looking for the equality of human beings, and we see how they struggled with it, and your opening statement certainly expresses how you have struggled with that like no one on this committee could really appreciate. It is particularly fitting that my first duty upon returning to the country is to consider the confirmation of a successor to a man who has been the champion and the forefront of the rights of the individuals during his long and distinguished service on the Supreme Court, and of course that's Thurgood Marshall. His legacy will surely serve as a model for the jurists in these emerging democracies and the justice system as they seek to protect their hard-fought struggle for individual rights and their freedoms. It's against this backdrop that I will listen to the response to some of the questions that I will submit to you and those that have already been asked to you. I hope that I will be able to conclude, Judge Thomas, that your judicial philosophy will first and foremost be dedicated to the protection of the rights of individuals. And Mr. Chairman, I request that the full statement that I would have given yesterday be inserted in the record in the proper place, if I may.
It will be placed in the record.
Thank you, Mr. Chairman. Judge Thomas, I'd like to pursue the Equal Protection Clause, the 14th Amendment, and how it relates to discrimination. As you so well know, but for purposes of clarity, the 14th Amendment prohibits a state from depriving a person of life, liberty, or property without due process of law or equal protection of those laws. The Equal Protection Clause provides the primary constitutional protection against laws that discriminate on the basis of gender. And as we also know from previous hearings, there are 3 tests. There's the rational relationship test. There's the, which is the most lenient of those tests. There's the intermediate scrutiny test, or a heightened test, which has been used in gender cases. And then there's the scrutiny test, which has been used in race and national origin. Judge Thomas, there's been much discussion already regarding reliance on natural law. And unfortunately, natural law has been invoked historically. Or maybe it's fortunate, depending on how you define it. But it goes back a long time that my staff was able to dig out. For example, in 1873, in the Bradwell versus Illinois case, the Supreme Court denied a woman a license to practice law, arguing the following: civil law, as well as nature herself, has always recognized a wide difference in the respective spheres and destinies of man and woman. The natural and proper delicacy which belong to the female sex evidently unfits it for many of the occupations of civil life. The paramount destiny and mission of women is to fulfill the noble and benign office of wife and mother. This is the law of the Creator." End of quote. Now, I know you went in with Senator Kennedy at some length about your position on natural law, which I did review this morning, and I welcome some clarifications that you have given. But with the Bradwell case, we see that those justices applied natural law. And I know that you stated that, that your duty would be to uphold the Constitution and not a natural law philosophy. But I'd like to just clarify for the record, do you disagree with the justices' decisions that was held back in 1873 in the Bradwell case?
Senator, I do.
Thank you. That's really all I want to know, because I want to be very clear, based on your statements to Senator Kennedy, that you don't have any lingering thoughts that stare decisis or what have you, dating back to a clear case where natural law was used, poses any problems to you.
No.
Thank you. When you were nominated, Judge Thomas, to the Court of Appeals, I submitted written questions because of time constraints and other things that prohibited me from coming to those hearings at any length and waiting my turn to ask you questions to comment on the Court's approach to the Equal Protection Clause. We also discussed this before these hearings when you were in to see me, and I told you I would address you with some questions and some thought on that. And in response to my written questions, your partial response was, though I do not have a fully developed constitutional philosophy, I have no personal reservations about applying the 3 standards as an appellate court judge in cases which might come before me. Now that you've been on the court for 18 months and may soon be making decisions on important equal protection cases on the highest court of the land, let me ask you if you have developed a constitutional philosophy regarding the court's 3-tier approach to the equal protection cases.
Senator, I have no reason and had no reason to question or to disagree with the 3-tier approach. Of course, the rational basis test being the least structured or least strict of the tests, the heightened scrutiny test, which has been used in the area of gender and alienage and legitimacy, and the strict scrutiny test, which has been used in the area of fundamental rights and race. Senator, I think that those tests attempt to, in our society, to demonstrate the concern that we have for classifications that could infringe on fundamental rights. And I believe that underlying, when we move away just from the legalese, and I do accept this structure, the three-tier test, when we move away from it at bottom, what we are talking about is, are we going to allow people to be treated in arbitrary ways, either because of their gender or because of their race? Are we going to defer to classifications based on gender or race? And what the court is attempting to do in an important way is to say, no, we're going to look at those classifications.
Thank you, Judge Thomas. That's helpful, and I guess it goes without saying, but I'm going to say it anyway. You have no agenda or hidden belief or anything else regarding the present position that the Supreme Court has taken with these three tiers on equal protection as they relate to gender or any other minority or class that it may be applied to.
Senator, I think it's important for judges not to have agendas or to have strong ideology or ideological views. That's baggage, I think, that you take to the court or you take as a judge. It is important for us, and I believe one of the justices whose name I can't recall right now spoke about having to strip down like a runner to eliminate agendas, to eliminate ideologies. And when one becomes a judge, it is an amazing process, because that's precisely what you start doing. Mm-hmm. You start putting the speeches away. You start putting the policy statements away. You begin to decline forming opinions in important areas that that could come before your court, because you want to be stripped down like a runner. So I have no agenda, Senator.
Thank you, Judge Thomas. Is it fair to say, then, your philosophical approach, not going to any specific case, that you would agree with this statement: if the court were to abandon the heightened scrutiny test as it is applied to sex discrimination, gender cases, etc., that it would be turning the clock back on equal protection rights of women?
Senator, I think that would be appropriate, an appropriate statement if you said either abandon or ratchet down.
Thank you very much, because it's so clear that if the court moves in that direction without touching the issue of abortion or what have you, it concerns me a great deal. Having studied it and having posed these questions to a number of nominees here, I really feel the court has, to the best it can with the variance of people that are on there, come to some relatively good conclusions. And though the intermediate scrutiny or heightened scrutiny may not be enough to satisfy the inequities in women's position and jobs and pay and what have you today, at least I'm satisfied that it gives a court an opportunity, as the cases come before it, to continue to improve the, quote, inequities, quote, that I believe women still suffer in our society. And I'm pleased with your responses. They're similar to those responses that Judge Souter gave, and maybe you listened to his testimony, but I'm very thankful for your candid approach, and also your gratuitous or your comments about an agenda. Because I agree with you, Judge Thomas, there's no place on the court for someone who has an agenda. We all have ideas and we have to express them. We're all raised in a certain way, and we all have certain convictions that we have to express and follow through once we're in a position of making a decision. But indeed, I take that as a very serious statement on your part. Justice Marshall had his own distinct approach to equal protection claims, as you may recall.
Marshall believed that the court does not apply a three-tier approach to equal protection claims, but rather a spectrum of standing, and I put quotes around that, a spectrum of standing review. Thus, the more important the constitutional and societal right given to an interest, the greater the scrutiny should be applied. Do you have any feelings about this distinction that Judge Marshall makes regarding the three-tier system that you've clearly said that you support, and this spectrum of standing in total society?
Senator, I've not examined Justice Marshall's approach in any detail, and have not had occasion to employ it in any of my analysis. But I think that what he's attempting to do is precisely what you're attempting to do with the three-tier analysis, and that is to adjust the scrutiny and to make it more exacting, the more significant and more important the right we are protecting. Maybe it would accomplish the same ends or be pretty close to the three-tier analysis, but it seems as though the objective is the same, but I have not had occasion to use it.
Is it fair to say from your comments then that you might come across a case regarding sex discrimination, that could fall into the strict scrutiny if it was such a blatant case that was not unisex toilets or something that is always used in the area of the intermediate scrutiny to show the difference in applying a strict scrutiny to all sex cases? Is that a fair statement, or can you comment on it?
Senator, I think that discrimination is, as I've said, a cancer on our society.
Can you comment on it?
Senator, I think that discrimination is, as I've said, a cancer on our society. There could be instances where one would want to apply a more exacting standard even than the current heightened scrutiny test. I would be concerned if we were to see a movement down toward the rational basis test. But I think that discrimination and classifications based on race or sex are so damaging to our society that, and to individuals in particular, that one could consider and be open to ratcheting up or applying a more exacting standard.
Thank you, Judge Thomas. I know yesterday with Senator Kennedy, you discussed the 1987 Atlantic Monthly article by Juan Williams, quote, "A Question of Fairness," I believe it's called, which was based on the extensive interview with you. In that article, Williams writes that you stated, among other things, blacks and women are generally unprepared to do certain kinds of work by their own choice. It could be that blacks chose not to study chemical engineering and that women chose to have babies instead of going to medical school. You also discussed with Senator Kennedy your support of the writings of Thomas Sowell. In an article you wrote for the Lincoln Review in 1988 titled Thomas Sowell and the Heritage of Lincoln, you praised Sowell's analysis of working women. And Sowell contended in a 1984 book that inequities in pay and career advancement stem from women's own behavior and preferences, claiming that women choose jobs and careers with lower pay and greater flexibility to accommodate their roles as wives and mothers. And I agree with you that Mr. Sowell certainly has a right to express his views. But my question to you is, do you agree with his conclusions on this particular statement and issues?
Senator, I think as I alluded to yesterday, to say that women brought discrimination on themselves or lower pay on themselves is going too far. The point that I attempted to make yesterday with Senator Kennedy was that you have to begin to disaggregate the numbers. you have to look more at the particular categories. You can't just have this average and say this is the problem. If you're going to address the problems, you have to engage in a process of disaggregation. There were questions on, I think that the comment yesterday by Senator Kennedy, I believe, was that something to the effect that women who were married weren't as good employees. And as an employer and someone who employed a significant number of women, I did not find that to be true, and made that very clear.
Sowell also explained pay inequities between the gender by claiming that, quote, women are typically not educated as often in such highly paid fields of mathematics, science, and engineering, nor attracted to physically taxing and well-paid fields such as construction work, lumberjacking, coal mining, and the likes. What's your thoughts about that conclusion?
Well, I can't say whether or not women are attracted or not attracted to those areas. I think that's a normative comment there. But I think his point that there are not women in some of the higher paying profession begs the question.
I do too.
There are reasons why, and some of those reasons could involve discrimination. Again, my point in saying that his arguments could be an anecdote to the debate is because he attempts to disaggregate and to not simply say all of the reasons are simply discrimination. There could be other reasons. It is not to say that I adopted, as I said yesterday, I believe, to Senator Kennedy, all of his conclusions and his assertions. I simply don't and did not at that time.
Thank you, Judge Thomas. Judge Thomas, I want to go into some areas that deal with Hispanic concerns. As a former chairman of the Equal Employment Opportunity Commission, you were responsible, and I'm sure you're familiar with the 1983 charge study. You weren't responsible, but I'm sure you're familiar with it, or I hope you are, entitled Analysis of the EEOC Service by Hispanics in the United States, which was conducted by the EEOC appointed task force. That task force concluded that the needs of Hispanics were not being adequately addressed by the EEOC. At the time, the task force indicated a need to improve EEOC's record of investigations of Hispanic charges and to increase outreach and education efforts within the Hispanic community. Now, as the Commissioner, what programs did you initiate to improve the accessibility of the EEOC within the Hispanic community?
Senator, when I arrived at EEOC, one of the first concerns among many, believe me, there were many, with which I was met, was that EEOC was underserving the Hispanic community. For example, in Los Angeles, and certainly in your home state. There were a number of hearings, some of which I participated in across the country in various major cities, discussing the problem and what the probable or possible responses could be. A number of the, I think, concerns were that the national origin charges were low. The problem there, of course, is that not all of the charges which we receive from Hispanic employees or Hispanic Americans are national origin charges. They go across the line. They could be involved on age. They could involve gender discrimination also. A number of the things that we did included opening offices in predominantly Hispanic communities, satellite offices. We had, that was a part of our expanded presence program. I made sure that we developed public service announcements that were bilingual. I installed a 1-800 number at EEOC so that the agency could be accessible. We developed posters that were bilingual. We took all of our documents, our brochures, and translated them to Spanish, into Spanish. The effort was to make sure that we reached out, that we included, and we also, in areas where we had it, there was a significant Hispanic population, we made every effort to see to it that the top managers and the investigators spoke Spanish. Again, the effort, the overall effort was to reach out, and that was consistent with the recommendations. I might also add that during the major part of my tenure, 2 of our 5 commissioners were also Hispanic. So there was considerable interest on my part, on their part, indeed the Commission's part, in being of greater service to Hispanic Americans.
How many offices did you open? Do you remember? In Hispanic
we opened, that's a good point. I can't remember the satellite offices, the exact number. I know we opened one in East LA, and we upgraded the office in San Antonio, Texas, from a smaller area office to a full-scale district office to better serve that
Did
community.
any of these programs include plans to recruit more Hispanics for the agency itself?
We attempted to do that in coordination with various individuals, but that's a more difficult proposition, and also to promote internally and to make sure that we had Hispanics promoted to jobs. But that can be frustrating. My efforts sometimes were met with individuals after you've positioned them for the senior position, they find other alternatives and leave the agency or other difficult personnel actions.
Judge, an interim result of a study conducted by the National Council of La Raza indicates that since the 1983 task force study, the situation at EEOC with regards to Hispanic has not improved. While the Hispanic population in the United States has grown in the last decade from 6% of the total U.S. population in 1980 to over 9% of the total population today, the percentage of the EEOC total charged caseloads filed by Hispanics was only 4.15%. Given your efforts to improve the EEOC record with regard to Hispanics since 1983, how do you account for the disproportionate small number of charges filed by Hispanics?
Again, Senator, I have and had the very same concern that we were underserving, or that EEOC during my tenure and when I arrived there was underserving the Hispanic community. I don't know how the numbers were arrived at. To my knowledge, the agency does not keep data in areas that does not involve, or areas that do not involve national origin charges by national origin. So I don't know, for example, whether we're looking at numbers reflecting only the national origin charges as opposed to other areas. I can say this, that we made every effort during my tenure to change the Commission's accessibility to Hispanic Americans, to individuals across this country. That was the purpose for our expanded presence program, for our satellite offices, for our educational programs, all of which were started during my tenure. Our outreach efforts were all designed so that we're not sitting in our offices waiting for people to come in, but we actually go to them. Sometimes it's frustrating because they don't all work, but it certainly was not because of a lack of trying.
Well, certainly it must be frustrating, Judge, because another area of concern is the disposition of charges filed by Hispanics. According to the National Council of La Raza report, the percentage of cases which were administratively closed without remedy to the charging party has increased from 45% in 1985 to 72% in 1990. I realize a little bit of that time you weren't there, but does this figure reflect a weakness in the EEOC effort to pursue complaints filed by Hispanics, or does it suggest that the incident of discrimination against Hispanics is lower than other protected groups?
Senator, again, I don't have that data, and this is the first I've heard of those numbers. I would not think, particularly with the office heads and the employees who would certainly be interested in the communities in which they investigate those charges, that it is a weakening in EEOC's efforts. Again, I don't have the data. It certainly doesn't reflect, not to my way of thinking, a reduction or a decline in discrimination.
It's your position that you were taking and following the recommendations of the 83 task force.
We did everything within our power during my tenure to reach out.
Well, did you really, Judge? Did you go and meet with the Council of La Raza, the GI Forum, or any of the other national or local Hispanic groups to see what they would suggest you do, or to ask for their counsel and suggestions and advice?
Senator, I can't name, again, it's sitting here, all the groups that I've met with, but one of our commissioners in particular was very, very active and he and I spent a great deal of time together, because he would go and he would report back on what the perceptions of the problems were and approaches that we could take. Again, he and I were there the entirety of my tenure, with the exception of a few months. And the second commissioner, who was also Hispanic, he and I worked very closely together to begin to address some of these problems. So, and I'm sure both of them were very active and very involved, and I think they would both tell you that I would always...
Judge, I appreciate that, but it doesn't answer my question. What did you do? Did you go out and seek to sit down with some of these national Hispanic groups regarding the problem, or was it kind of your attitude, look, I got 2 Hispanics here, I'll let them take care of that, I'm going to take care of other areas that I think are of primary concern to me? You know, I get a feeling that you didn't pay attention yourself to Hispanics, and that doesn't mean I'm going to vote against you or for you because of that single issue, because I don't make any decisions that way, but I get a feeling that while you were there, that was not high on your priority list, that you left it to the 2 Hispanic commissioners and you did something else, but yet you were the chairman.
Senator, I can assure you that I traveled over this country to meet with various groups. I can't tell you precisely right now which groups I met with. I know I met with any number of Hispanic groups in my efforts to change the way that the agency was responding. I believe that discrimination in this country, whether it's race, gender, national origin, religion, age, that all of it is wrong.
I don't question that, Judge.
And what I attempted to do was to equalize treatment at the agency of all the areas. I was outside of the agency to visit with these organizations. I can't tell you which ones. I certainly tried to work with a number of the organizations. Some I had better relationships with it during my tenure than others.
Well, maybe you could help us, I don't know if you have time or somebody can help you, to go back over your calendar. I'd like to know who you did meet with in the Hispanic area, because it might put to rest the feeling I have is that you really were not paying attention to Hispanics. Maybe not because you didn't like them, I'm sure that isn't the case. Maybe it's because you were so busy dealing with women's issues and black discrimination, I don't know, but I get that feeling, and from the opposition that has come forward from the Hispanic community, you certainly didn't leave them with any great impression that you were interested in their problem, Judge.
Well, Senator, I was, and I tried to resolve the problems. As all of us know, when you run an agency as spread out as EEOC and with a difficult mission that we had, that you have your frustrations, and I certainly had my share, but I can assure you that I tried to reach out to all the groups.
My time is up, Judge, and I'll come back to this and a couple other areas later. Thank you, Judge Thomas, for...
Thank you very much. Senator Grassley.
Mr. Chairman, I would like to make sure that a letter sent to you and Senator Thurmond from former Attorney General Benjamin Civiletti is introduced in the record, and I'd like to note as a statement in that record, besides the fact that Mr. Civiletti is served the Carter administration. He has testified in support, or has asked to testify in support of Judge Thomas, and these are some words he used: finding his tenacity and strength of character to be positive attributes for the work of the court. So I'd like to submit that for the record.
Without objection, and I can assure the Senator that General Civiletti has been invited to testify. We look forward to hearing his testimony.
Okay. Judge Thomas, again, I want to welcome you, and particularly welcome you and your family, and I've admired how patient they've been sitting through all this. They're to be complimented, and particularly complimented for their support of you during this time of trial, although you tend to be handling the trial very well. I don't know what your son's career is going to be, but I'm sure it's not going to be in law after he observes what you go through. Much of the discussion has focused on natural law, and while I've listened intently to this and have some questions in that area, I would like to pursue what I believe is a related subject, judicial restraint. An understanding of your view on the role of the courts in our democracy will, I really think, give us a better understanding of where natural law fits into your judicial philosophy. The founding fathers, as Alexander Hamilton wrote in the Federalist Papers 78, intended the judiciary to be, in their words, the least dangerous branch of government. Now, in your writings and speeches, you've cited Hamilton's framework for federal power, power based on the sword, the purse, and the power of reason. You said the president would hold the power of the sword, the Congress the power of the purse. Now, to the judiciary, having neither power of the purse or sword, you have said would derive its power and influence from its ability to provide reasoned and persuasive decisions, establishing sound, legitimate reasons for every dispute that it decided. I understand what you have said here to mean that judges would have to be fair, unbiased, open-minded, devoted to addressing the facts and the law before them, without freedom to apply their own values in reaching a decision. I'd like to refer to what Judge Harlan Fiske Stone expressed well when he wrote, and then this will bring me to a question for you, and this is Justice Stone: while the unconstitutional exercise of power by the executive and legislative branches of government is subject to judicial restraint, the only check upon our exercise of power is our own sense of self-restraint. End of quote. Yesterday, you told Senator Hatch that there was no room to apply personal philosophies in one's effort to adjudicate cases. In my first question, I hope that you'll reaffirm what you said along this line in your confirmation hearings for the D.C. Court of Appeals, the D.C. Circuit. You said, quote, "The ultimate goal should always be to apply the will of Congress, the will of the legislature. I don't think that it's ever appropriate for a judge to replace the intent of the legislature with her own intent." Is that something you can reaffirm today after being on the Circuit Court of Appeals?
Senator, when I spoke those words in my confirmation hearing for the Court of Appeals, of course, I had not been a judge. But now I can reaffirm those words with the experience of having had to be a judge and having had to judge in some difficult cases. I do not believe that there is room in opinions in our work of judging for the personal predilections, the personal opinions and views of judges. I think in statutory construction, the ultimate goal for us is to determine the will of the legislature, the intent of the legislature, not what we would have replaced the legislative enactment with if we were in the legislature. and we have no role in legislating.
To continue along the same line, it seems to me your notion of the role of courts is very similar to that of Justice Anthony Kennedy. He cautioned that judges are not to make laws, they are to enforce the laws. He said the courts could not be the aristocracy of the robe, that is to say, black robes of a judge give the individual no special mandate to declare the law. How close would you be to the statement made by Judge Kennedy?
I think, Senator, that we all who've been judges are pretty close to the same statement. We recognize that when we sit to judge cases, that we have to be open and we have to think, and we recognize our fallibility, as I said yesterday. But we also have to recognize, and this is something that I do before I sit down in each case, in all of the cases that I've sat on in the Court of Appeals, I ask myself a very simple question: what is the role of a judge in this case? I think that's an important question. It's not so much to determine that we're going to in any way constrain the development of individual rights. Indeed, I'm for the robust development of those rights. But rather, it's a question to restrain judges and to restrain me so that I have a confined and defined role.
I like those responses, but let me now refer to a speech you gave that maybe on my reading of it bothers me, maybe on your explanation of it you can clear it up. But I'd like to contrast with what you said and also what you said in the earlier confirmation hearing for the D.C. Circuit Court of Appeals with a speech at Wake Forest University in '88. And I do have a copy of the speech if you want me to give it to you. There you said, quote, "Once a law passes, the action shifts to the problem of administration. It is up to the courts and the bureaucracy to fill in generalities and sometimes resolve the contradictions of the law." Now, the reason this concerns me is because it's vaguely like something Justice Souter said in response to some of my questions last year, that the courts, and these are his words, fills vacuums left by Congress. That statement, of course, troubled me a year ago. He later somewhat qualified it in responses to additional questions the following day. I guess my question is, very basic. How much filling in are you going to do as a Supreme Court justice? I hope you can clarify something here. Do you think that there's a role for the courts to be activists this way in the terms of filling vacuums, or, as you said, filling in the generalities and resolving contradictions of the law? Maybe in a wider area, I'd want you to explain when is judicial activism legitimate?
I don't think that it is legitimate, Senator, and perhaps let me respond to your specific question. The point that I was making there, and it's one that is an important point, is that when an agency, an administrative agency, receives a statute, it is called upon to implement that statute, to develop regulations, perhaps internal rulings or procedures. But it's always called upon to do that consistent with the intent of this body. That the statute on its face may be general, it may be ambiguous. The agency has to go through a process, however, of determining in a reasonable way what your intent was. I think a court does the same thing, that when there is ambiguity in the statute, the court simply goes back to your legislative history and attempts to discern what was Congress's intent. To the extent that we're talking about filling in that instance, I think it's simply a process of statutory interpretation and development of rulemaking within the agency or the administrative bodies in the executive branch.
Judge Scalia testified here and has practiced it as a justice, that in looking at history, he's not going to look to the committee reports. He's not going to look to congressional debate. He's going to look at the statute and just determine congressional intent from the language of the statute. Is that where you're going to get congressional intent?
Senator, I don't know how you can resolve ambiguities in statutes. And when we do have ambiguities in statute, then we look to legislative history. We look to the debates on the floor, of course. We look to committee reports, conference reports. We look to indications, the best indications of what your intent was. And of course, some legislative history is perhaps more accurate or better than others, but the point is our effort is always to look for your intent, to discern your intent. I don't know how one can go about that process, the process of interpreting ambiguous statutes without looking to legislative history.
Let me go to maybe along the same line, but to some specific cases you've been involved in, because the docket of the court you now sit on is filled with regulatory cases. And in this position, I think a judge could be tempted with such a big caseload to direct and manage the bureaucracy, and of course thereby substituting his or her own judgment for that of a more politically accountable administrative agency. And in fact, one of your colleagues, Judge Mikva, has written that the court should be on the lookout for, and this is as he termed it, a sudden and profound change in agency policies, as such changes constitute, in his words, danger signals and give license for court intervention and agency action, in his view. Considering this, I was struck by your opinion in Citizens Against Burlington versus Bussey. That's a Toledo Airport expansion case. Your opinion expresses some important elements of judicial restraint. You found that the FAA, in reviewing the expansion plans, carried out its lawful authority. The plaintiffs wanted more review of the environmental issues. What do you base your decision on? Your opinion, I should say.
First of all, let me say, Senator, that Chief Judge Mikva and I and our other colleagues work together very well and have very vigorous debate internally on these important issues, and I enjoy sitting with him as a colleague. In this case, the initial question was this: in determining whether or not or where Burlington Northern was to place its hub, who makes that initial decision, or who determines the objective or the goal of the project? And if the objective or the goal of the project is determined in a broad way, that is, Burlington Northern is entitled, the goal is to a hub, then the alternative to be explored can be very significant. They can be countless. A hub where in the United States? Or is the determination of the goal or objective to be made by the city of Toledo and Burlington? That is, Burlington wants a hub in Toledo. Then the question becomes that the alternative is between that specific hub and no project at all. And what we, in essence, found was that the decision should have rested, the goal, the objective of the project rested with the individuals who were applying for the FAA permission to build a hub, rather than this broad expanse of possibilities.
Let me quote briefly from that opinion of yours. And I guess you're, not that you need to react, but I want to know if this is good basis for me to judge your opinion of judicial restraint. Federal judges enforce the statute, in this case it was the National Environmental Policy Act, by ensuring that agencies comply with NEPA's procedures and not by trying to coax agency decision makers to reach certain results. We are forbidden from taking sides in the debate over the merits of developing the Toledo Express Airport. We are required instead only to confirm that the FAA has fulfilled its statutory obligation. Congress wanted the agencies, not the courts, to evaluate plans to reduce environmental damage. But the federal courts are neither empowered nor competent to micromanage strategies for saving the nation's parklands. That's you.
I think that Senator, was my view, my opinion as to what the intent of this body was, and my effort was to faithfully apply that and adjudicating in that particular case.
There are a lot of other cases like that I'd like to go over, but let me just do one more. It's your concurrence in the Cross Sound Ferry versus Interstate Commerce Commission. The case involved the issue of standing. You agreed with Judge Mikva's result, but just not the reasoning. Is that correct?
That's right. I concurred in the result in that case, Senator.
I'd like to have you elaborate on those differences of views between Judge Mikva on the one hand and your reasoning on the other.
My concurrence, the purpose was really a simple question. One of the challenger, the case involved two ferry companies. One was an established ferry company, and there was a newcomer who wanted to travel back and forth across Long Island Sound. ICC determined that the newcomer was exempted from regulation. As we reviewed the case, one of the challenges was by the existing ferry company that the ICC should have required of the newcomer and a filing or compliance with two environmental regulations, NEPA and the Coastal Zone Management Act. The question was, for me, initially, the question that I ask in all cases that, and in all areas, do we have jurisdiction to consider this? And there is an argument that sometimes that when the merits of the case are easy and the jurisdictional component of the case is hard, that it's easy enough to skip over determining jurisdiction and determine the easy merits portion of the case. My point in the concurrence was that it was inappropriate to skip over the jurisdiction determination to get to the merits, that federal judges had an obligation to determine at each turn whether or not we as judges had any role in that particular case. And my view was that there was no standing to raise the issue on the part of the existing ferry company.
One sentence that you said in that decision, federal courts are courts of limited jurisdiction. When federal jurisdiction does not exist, federal judges have no authority to exercise it, even if everyone, judges, parties, members of the public, want the dispute resolved. Seems to me like you set a very narrow role for the courts. And and my question then, in regard to going to the Supreme Court, that you assume that's going to be the same philosophy you start with on standing and other things?
Senator, I don't think that we as judges should be stingy or crabbed in our view of individuals' access to our judicial system. I think it is important, as I said yesterday, that the courts in our judicial system be available to all, that they have a place where their case can be adjudicated in a fair way. My concern, however, is that we are judges who are required to determine what our jurisdiction is before we can decide a case. And I see that more as a restraint on us than it is on the individual having access to the court system, although the two, of course, could ultimately be the same thing in some cases. But the jurisdictional determination, to me, is an important determination.
The doctrines of standing are limitations on the exercise of judicial power. Your opinions, to me, are good examples of how a judge must restrain himself or herself in exercising power he or she possesses. And has that general approach, maybe you've had it throughout your lifetime as a lawyer, but has this been strengthened in the year or 2 years you've been on the circuit court?
Senator, a couple of points. I think when one becomes a judge, as I've noted earlier, one begins to realize the difficulty of the cases that come before us. You don't have the comfort of your position as an advocate. You don't reinforce your own arguments. You've got to listen to all the arguments. And the arguments can be equally forceful on either side. So I think that when we recognize our own fallibility and our own humility, we become concerned about what our role is in each of these cases, which is the second point. And we ask ourselves, do we belong in this case? What is our role? Do we have the authority? And one learns a sense of humility. So I would say that my view, and one also recognizes, Senator, I might add, that we are the least democratic branch of the government. And we have to restrain ourselves as judges. And I think that's important. Indeed, I think it's critical, so that we do not begin to see ourselves as super legislators.
Right there, let me say that what you've just said, it seems to me like, is what Judge Scalia described himself and his colleagues on the High Court as the unelected and life-tenured judges who have been awarded extraordinary undemocratic characteristics. And that was from a concurrence that Scalia wrote in the Webster case. And that's your approach. Your approach would be similar to Scalia's then. I mean, I think you said the same thing.
I think if his point is, Senator, that we are not elected to make policy, we're not in the position to make the kinds of difficult decisions that the elected, the political branches make, then I think he is right. We are judges, and I don't think that we should stray beyond our role in the undemocratic, the most undemocratic branch of the government into the political, the authority and the role of the political branches.
Well, the political branches, too, have great responsibility to protect our liberties. And since judges are not accountable to the body politic and should not have the responsibility of deciding sensitive and controversial issues of the day, and that's judicial activism, that's legislating, judges trying to do our job from the bench. I guess I need to have you tell Americans what you see as the dangers of judges substituting their ideas for those of the political branches of government.
Senator, I think that briefly the danger is inherent in the fact that there are no checks and balances as you have in the political branches for judges. We don't stand for elections. If we do the wrong things, we're not challenged by an opponent, and we don't lose our incumbencies as an elected official. We don't have to go back to our districts and be told that we've done the wrong thing. We are lifetime appointments, and I think there's a danger with the lack of that check, the lack of that exposure to elections, and the lack of the tensions between the political branches, that we could do things that, as judges, that we think are nothing more than a matter of our personal opinions. And I think it would be inappropriate. I think it's a very significant danger.
I would ask if you would, in just what you said, if you'd be standing behind a 87 speech that you gave before the Cato Institute, the quote, when political decisions have been made by judges, they have lacked the moral authority of the majority. When courts have made important political and social decisions in the absence of majority support, they have only exacerbated the controversies. So by leaving my questions, in a sense, is then you're saying leaving the difficult, sometimes contentious decisions to the elected representatives, then there should be no concern or fear among the American people.
I think that, of course, Senator, we always have concerns and fears and different points of views, and there's always debate and give and take. But I think that those political decisions, those policies, should be developed and debated and established in and by the legislature. That the judge's role is not to legislate and it's not to set policy, and it's certainly not to engage in political decision making.
There may be a trend away from judicial activism, but I don't think we've seen the last of it. I'd like to draw your attention to some recent cases in which district judges engaged in judicial activism. The first is a case that arose in a New Jersey federal court. It was in Morristown. The Public Library Board of Trustees issued regulations designed to ensure that the library did not become home to vagrants. The regulations required that patrons use the library as it was intended to be used, that is, for reading, studying, or using library material. So the court struck down the library's regulations, saying that everyone has a right to receive ideas and the library cannot restrict access. There was a New York federal judge just this past June found that panhandling might be protected speech under the First Amendment, and this was despite the fact that a Second Circuit ruling to the contrary from last year. Now, I realize that you're going to be reluctant to comment on the merits of these cases since such issues could come before the Supreme Court, but I hope, and I suppose this is more of a statement than question, no, I guess I'd really want it to be a question. Can you see these as examples of a court's usurping the function of legislative bodies and making rather than applying or interpreting law?
Senator, unfortunately, I don't know the full facts in those cases, and I think it would be inappropriate for me to try to comment on those particular cases. But let me just simply say this, that I think that we all as judges should be concerned and should be aware, or at least be cautious not to move into areas that are best left to the, as I said, the political branches and to the legislature. But those specific cases, I simply don't know the details of them, and I think even if I did, it would be inappropriate to comment on them.
Okay. Maybe it is, but let me make this point to you to think about then, whether or not those cases might not be inconsistent with a point you made in that 87 Cato Institute talk, where you stated, and quote, maximization of rights is perfectly compatible with total government regulation. unbound by notions of obligation and justice. The desire to protect rights simply plays into the hands of those who advocate a total state. The rhetoric of freedom, in parentheses, license really, end of parentheses, encourages the expansion of bureaucratic government. My time's up. I just want to leave the subject with a quote from Felix Frankfurter on the role of judges. He found that the duty not to enlarge his authority to be one of the greatest challenges of being a judge. He continued, and let me quote probably about 40 words, that the court is not the maker of policy, but is concerned solely with the question of ultimate power, is a tenet by which all justices have subscribed. But the extent to which they have translated faith into works probably marks the deepest cleavage among the men who have sat on the Supreme Court. The conception of significant achievement on the Supreme Court has been too much identified with largeness of utterness and too little governed by inquiry into the extent to which the judges have fulfilled their professed role in the American constitutional system. End of quote. I hope I see your confirmation bringing to the Supreme Court one more person like Felix Frankfurter, who's going to be looking at and inquiring into the extent to which judges have fulfilled their role in the American constitutional system. Thank you, Mr. Chairman.
Thank you, Senator, and thank you, Judge. We will adjourn until, we'll recess until 2 p.m.
To the U.S. Court of Appeals for the District of Columbia Circuit.
Order this afternoon.
Sorry. Hearing will come to order. The chair recognizes Senator Leahy.
Thank you very much, Mr. Chairman. Judge Thomas, welcome back this afternoon. Judge, I'd like to just go over a couple points prompted by some of your earlier testimony. A couple of thoughts that occur to me. I was looking over the notes of your responses to Senator Kennedy's questions yesterday. You recall them when he talked about the Lewis Lehrman article, the Declaration of Independence and the Right to Life, and he referred to your statement, which you'd called the Lehrman article a, quote, splendid example of applying natural law. Now, I understand your answer was that you were speaking in the Lewis Lehrman auditorium with Lewis Lehrman sitting there and referred to Lewis Lehrman's article, and that you intended to make your conservative audience more receptive to natural law principles as it applied to civil rights. Is that a fair statement restatement of your answer?
I think with the possible exception of Lou Lehrman sitting there.
Oh, that's my misconception. He was not there then.
Not to my knowledge.
Okay. My note was wrong on that. But the rest as to your reason for doing it was a fair restatement. Thank you. Now, so granting that it was a strategic remark for the reasons that you stated, did you believe the article was, quote, a splendid example of applying natural law?
As I indicated yesterday, Senator, that I did not and do not think that the natural law can be applied to resolve this particular issue. I think that this is a constitutional matter and it has to be resolved under constitutional law, as a matter of constitutional law.
But that's not precisely my question. My question was, did you believe the article was a splendid example of applying natural law, just on that narrow line, do you believe the article itself was, quote, a splendid example of applying natural law?
Well, let me explain what I was trying to say. What I was
You
trying
can't
to,
answer that specific question.
yeah, what I'm trying to say, so I'm not misunderstood, Senator. What I was trying to say is, here is a good
I don't know
example.
whether Senator Thurman wishes to join him at the witness stand, but go ahead, Judge.
Here's
I'll
an
be
ex-
glad to do it, but he's got a right to explain his answers.
Go ahead, Judge.
Thank you, Senator. My point was that here's an example of one of yours using natural law. I was not commenting on the substance of his use. So it was an example, it was a splendid example in the sense that it's a compliment to him, and it's a compliment to someone they believed in. And I reaffirm what I said yesterday, and I've said consistently, and that is that at no time did I adopt or endorse the substance of the article itself. My interest in that one sentence, I believe, was to get a conservative audience that was skeptical of a concept to be more receptive to that concept in the area that I wanted to use, in the area of civil rights. That speech is on the treatment of blacks by conservatives, treatment of minority issues in the Reagan administration, and a sort of request and a push or a tug to them to be more receptive in this area and to be aggressive in this area. It was not an endorsement of that article.
Do you feel that your answer today is any way inconsistent with what you said then?
What I said?
At that time?
Yes.
Thank you. Then you understand my confusion in two answers. But you explain that confusion in that the statement then your answer today are inconsistent.
I said they were consistent.
Oh, okay, well then you feel your answer today is consistent with what you said back at the time you spoke in the Lewis Lehrman auditorium.
Senator, my statement today is consistent with what I intended to do and what I did in the Lou Lehrman auditorium. My interest, as I indicated to you, and I think I've repeated a number of times here, it was in civil rights and finding unifying principles in the area of civil rights.
Well, let me make sure that I understand. Is it your testimony here today and yesterday that you do not endorse the Lewis Lehrman article in the extent that it argues that under the natural law principles of the Declaration of Independence, a fetus has an inalienable right to life from the moment of conception? Is that your testimony?
I do not. My testimony is that with respect to those issues, the issues involved or implicated in the issue of abortion, I do not believe that Mr. Lehrman's application of natural law is appropriate.
Had you read that article before you praised it?
I think I skimmed it, Senator. My interest, again, was in the fact that he used the notion or the concept of natural law. And my idea was to import that notion to something that I was very interested in.
Now, you certainly...
Did you say you do not believe that Mr. Lehrman's application of natural law in that article was appropriate? You do not believe it was appropriate?
Right.
Thank you.
I said that my testimony has been that that difficult issue is to be resolved as a matter of constitutional law.
Well, the chairman has anticipated my next question, so let me go after that. When you gave the speech, which was 1987, as I recall the testimony, did you understand that the consequences of Mr. Lehrman's position was not that just that Roe versus Wade should be overturned, but that abortion, even in cases of rape and incest, should be banned in every state of the Union. Did you understand that to be the position that he was taking in that article?
Senator, excuse me, Senator, until recently, in reflecting on it, I did not know, I could not recall the entire content of that article until I read recent articles about it. Again, my interest was very, very limited.
I understand.
And
you have read the article now, though, now that it's been brought up.
I've not reread it. I've not reread the article. I have not reread the article.
Do you have the article?
I do not have it with me.
Somebody want to just I'll make sure somebody gives it to you, Judge, but let me then accept this, that the article as written takes a position that not just Roe versus Wade should be overturned, but that abortion, even in cases of rape and incest, should be banned in every state of the Union. Assuming that that is the thrust of one of the main points of the article, do you agree with that?
Again, Senator, it would be, I think, for me to respond to what my views are on those particular issues would really undermine my ability to be impartial in those cases. I've attempted to respond as candidly and openly as I possibly can without in any way undermining or compromising my ability to rule on these cases.
Let's just go then to Mr. Lehrman's positions. Under his theory of natural law, that would criminalize every abortion in this country. Do you understand that to be his position? I'm not asking you whether it's yours, but do you understand that to be his position in that article?
Again, I would have to reread the article, Senator. I understand the criticisms that you have of the article, but my point to you here today, as well as in other questioning concerning this article, is that I did not adopt or import anything more from this article than the use of this one notion of natural law.
When I ask you to do this, then, Judge, because we will have another go-around this, it would only take about 4 or 5 minutes to read that article sometime between now and the next go-around. Could you please find the time to read it? And if you get crammed with too many things between now and then, when I get my next turnaround, I'll just stop and give you time to read it right then.
Okay. Okay.
Now, Mr. Lehrman drew a parallel between the struggle for liberty by slaves with the struggle for, quote, the inalienable right to life of the child in the womb, and thus the right to life of all future generations. You understand the parallel between the struggle for liberty by slaves with the struggle for the inalienable right to life of the child in the womb, and thus the right to life of all future generations. Do you agree with that comparison?
Again, Senator, I have not reread this article. I would take you up on your offer to go back and reread it. My interest was on the issue of slavery, Senator. It was an important issue to me. The concept of liberty and life, et cetera, are very general concepts. I would like to just take the time to go back and reread it and be fair in my response to you.
I absolutely agree.
But let me, if I could say this. My interest in this article was, as I have testified before this committee and I think indicated in some of our prior meetings, it was very important to me to convince conservatives that they should openly support and be aggressive in their support of civil rights.
Judge, does a fetus have a constitutional status as a person?
Senator, I can't think of any cases that have held that. I would have to go back and rethink that. I can't think of any cases that have held that.
If somebody were to raise that issue in a court, how would a judge go about making a determination of that? I'm not asking you to make a determination, but how do they do that? What kind, do they go to medical texts, philosophical texts, theological treatises? How does one make such a determination?
Senator, I can only offer this, and I have not made that determination. And I've not gone through that kind of an analysis. But of course, one would rely, in any case in which one is making a difficult determination, one will rely on the adversarial process to sharpen the issues. One would rely on precedent. One would certainly rely on related areas, such as the area of medicine. I think in the area in Roe v. Wade, I think that there was considerable reliance on medical evidence. But again, I'm doing that in a vacuum.
Sure. I will understand.
And
of course, even in the adversarial process, a judge can oftentimes shape and direct even some of the adversarial, and I mean in a most appropriate way. If they, any judge I've ever appeared before, if he or she felt that either the adversaries did not present enough to help the judge make up their mind, you certainly have the right to ask the adversaries present more of this, present more of that. In an area like this, do you rely on theology? Do you rely on jurisprudence? Do you rely on medical? Or do you rely on experience?
Senator, again, I would like to just simply say that of course, one could see where medical, certainly experience, and one could see where precedents would be relevant. I don't see at this point where theology would be relevant. But again, I would like to refrain from further speculation in this very difficult area. The point that I'm making to you, and I think it's an important point, is that when a judge is engaged in any kind of an effort to make difficult decisions in any area, a judge tries to examine the relevant evidence and tries to reach a reasoned conclusion, and tries to reach a conclusion without implicating or without involving his or her personal opinions.
Judge, you were in law school at the time Roe versus Wade was decided. That was 18 years, 17, 18 years ago. Now, I would assume, well, let me back up this way. You would accept, would you not, that in the last generation, Roe versus Wade is certainly one of the more important cases to be decided by the U.S. Supreme Court?
I would accept that it's certainly been one of the more important, as well as one that has been one of the more highly publicized and debated cases.
So I would assume that it'd be safe to assume that when that came down, you're in law school where recent case law is discussed, the Roe versus Wade would have been discussed in the law school while you were there.
The case that I remember being discussed most during my early part of law school was I believe in my small group with Thomas Emerson, may have been Griswold, since he argued that, and we may have touched on Roe v. Wade at some point and debated that, but let me add one point to that. Because I was a married student and I worked, I did not spend a lot of time around the law school doing what the other students enjoyed so much, and that's debating all the current cases and all of the slip opinions. My schedule was such that I went to classes and generally went to work and went home.
Well, Judge Thomas, I was a married law student who also worked, but I also found that at least between classes we did discuss some of the law, and I'm sure you're not suggesting that there wasn't any discussion at any time of Roe versus Wade.
I cannot. Senator, I cannot remember personally engaging in those discussions. Okay. The groups that I met with at that time during my years in law school were small study groups.
Have you ever had discussion of Roe versus Wade, other than in this room? In the 17 or 18 years it's been there?
Only, I guess, Senator, in the fact that in the most general sense that other individuals express concerns one way or the other, and you listen and you try to be thoughtful. If you're asking me whether or not I've ever debated the contents of it, the answer to that is no, Senator.
Have you ever, private gatherings otherwise, stated whether you felt that it was properly decided or not?
Senator, in trying to recall and reflect on that, I don't recollect commenting one way or the other on. There were, again, debates about it in various places, but I generally did not participate. I don't remember or recall participating, Senator.
So you don't ever recall stating whether you thought it was properly decided or not?
I can't recall saying one way or the other, Senator.
Well, was it properly decided or not?
Senator, I think that's where I just have to say what I've said before, that to comment on the holding in that case would compromise my ability to rule.
Let me ask you this. Have you made any decision in your own mind whether you feel Roe versus Wade was properly decided or not, without stating what that decision is?
I have not made, Senator, a decision one way or the other with respect to that important decision.
When you came up for confirmation last time for the Circuit Court of Appeals, did you consider your feelings on Roe versus Wade? Should you have been asked?
I had not been. Would I have considered, Senator, or did I consider?
Oh, did you consider?
No, Senator.
So you have not, you cannot recollect ever taking a position whether it's properly decided or not properly decided, and you do not have one here that you would share with us today?
I do not have a position to share with you here today on the whether or not that case was properly decided. And Senator, I think that it's appropriate to just simply state that it is for a judge that it's late in the day as a judge to begin to decide whether cases are rightly or wrongly decided when one's on the bench. I truly believe that doing that undermines your ability to rule on those cases.
Well, with all due respect, Judge, I have some difficulty with your answer, that somehow this has been so far removed from your discussions or feelings during the years since it was decided while you were in law school. You participated in a working group that criticized Roe. You cited Roe in a footnote to your article on the Privileges or Immunity Clause. You've referred to Louis Lehrman's article on the meaning of the right to life. You specifically referred to abortion in a column in the Chicago Defender. I cannot believe that all of this was done in a vacuum, absent some very clear considerations of Roe versus Wade, and in fact, twice specifically citing Roe versus Wade.
Senator, your question to me was, did I debate the contents of Roe versus Wade, the outcome in Roe versus Wade? Do I have this day an opinion, a personal opinion, on the outcome in Roe versus Wade? And my answer to you is that I do not.
Notwithstanding the citing of it in the article on privileges and immunities, not standing the working group that criticized Roe?
I'd like to have the cite to it. Again, notwithstanding the citation, if there is one, I did not and do not have a position on the outcome. With respect to the working group, Senator, as I have indicated, the working group did not include the drafting by that working group of the final report. My involvement in that working group was to submit a memorandum that I felt was an important one, on the issue of low-income families. And I thought that that was an important contribution and one that should have been a central part in the report. But with respect to the other comments, I did not participate in those comments.
Well, let us, I'll make sure that you have an opportunity to read both the footnote citation and the Lewis Lehrman article before we get another go-around. But am I also correct in characterizing part of your testimony here today that you feel as a sitting judge it would be improper even to express an opinion on Roe versus Wade if you do have one?
That's right, Senator. I think the important thing for me as a judge, Senator, has been to maintain my impartiality. When one is in the executive branch, and I've been in the executive branch, and I've tried to engage in debate and tried to advance the ball in discussions, tried to be a good advocate for my points of views and listen to other points of views. But when you move to the executive, when you move to the judiciary, I don't think that you can afford to continue to accumulate opinions in areas that are strongly controverted, because those issues will eventually be before the court in some form or another.
Well, of course, as Senator Metzenbaum pointed out earlier today, you have spoken to a number of cases, and I understand your differentiation in your answers to his question on that. But I wonder if they are somehow fit in a different category. Obviously, the expression once was that the Supreme Court reads the newspapers, and I suppose we can update that today to say that Supreme Court nominees read the newspapers, and you know that this was going to be an issue brought up. But, Judge, other sitting justices have expressed views on key issues such as, well, take Roe versus Wade. Justice Scalia has expressed opposition to Roe. Does that disqualify him if it comes up? Justice Blackmun, who not only wrote the decision but has spoken in various forums about why it was a good decision. Are either one of them disqualified from hearing abortion cases as a result of that?
Senator, I think that each one of them has to determine in his mind at what point do they compromise their impartiality, or it is perceived that they have compromised their objectivity or their ability to sit fairly on those cases. And I think for me, shortly after I went on the Court of Appeals, I remember chatting with a friend just about current events and issues. And I can remember her saying to me, asking me 3 or 4 times what my opinion was on a number of issues, and my declining to answer questions that when I was in the executive branch, I would have freely answered. And her point was that I was worthless as a conversationalist now because I had no views on these issues. And I told her that I had changed roles, and the role that I had was one that did not permit me or did not comport with accumulating points of views.
Well, I might just state parenthetically, I've been both a prosecutor and a defense attorney, and I've been 4 judges that have expressed very strong views on the idea that they don't somehow become, well, they've gone on the bench, they haven't gone in a monastery, and they still they're part of the populace and express views. And I've been there where they've expressed views both for and against a position that client I might be representing, whether it was a state in one hand or a defendant in another. But I've also felt secure in knowing that they were fair-minded people and would set their own personal opinions aside, as judges are supposed to, and as you've testified one should do in such a case. Let me ask you this. Would you keep an open mind on cases which concern the question of whether the 9th Amendment protected a given right? I would assume you would answer yes.
On the 9th Amendment, I think the only concern I've expressed with respect to the 9th Amendment, Senator, has been a generic one, and one that I think that we all would have with the more open-ended provisions in the Constitution. and that is that a judge who is adjudicating under those open-ended provisions tether his or her ruling to something other than his or her personal point of view. Now, the Ninth Amendment has, to my knowledge, not been used to decide a particular case by a majority of the Supreme Court. And there hasn't been as much written on that as some of the other amendments. That does not mean, however, that
is not what I'm sorry, I didn't hear that.
That does not mean, however, that there couldn't be a case that argues or uses the Ninth Amendment as a basis for an asserted right that could come before the court that does not, that the court or myself, if I'm fortunate enough to be confirmed, would not be open to hearing and open to deciding.
But you're saying that you'd have an open mind on Ninth Amendment cases.
That's right.
Because I asked that because you've expressed some very strong views, as you know better than all, on the Ninth Amendment. And you had an article that was reprinted in a Cato Institute book. Article, the book was on the Reagan years, but you referred to Justice Goldberg's invention using the Ninth Amendment in his concurring opinion in Griswold. And you said, and let me quote from you, you said, far from being a protection, the Ninth Amendment will likely become an additional weapon for the enemies of freedom. Pretty strong statement. But you would say, would you not, Judge, notwithstanding that strong statement, if a Ninth Amendment case came before you, you'd have an open mind?
Again, Senator, as I noted, that my concern was that I didn't believe that, that in such an open-ended provision as the Ninth Amendment, it was my view that a judge would have to tether his or her view or his or her interpretation to something other than just their feeling that this right is okay or that right is okay. I believe the approach that Justice Harlan took in Poe v. Ullman and again reaffirmed in Griswold in determining or assessing the right of privacy was an appropriate way to go.
That's not really my point. The point I'm making is that you expressed some very strong views, and you have here too, about the Ninth Amendment. But my question is, if, notwithstanding those very strong views you've expressed about the Ninth Amendment, pretty adverse views about it, would you have an open mind in a case before you where somebody's relying on the Ninth Amendment?
The answer to that is, Senator, yes.
But if you were to express similar views regarding the principles and reasoning of Roe versus Wade, you feel that somehow it would preclude you from having that same kind of objectivity as the reasoning you've expressed in the Ninth Amendment?
I don't believe, Senator, that I've expressed any view on the Ninth Amendment beyond what I've said in this hearing after becoming a member of the judiciary. As I pointed out, I think it's important that when one becomes a member of the judiciary, that one ceases to accumulate strong viewpoints and rather begin to, as I noted earlier, to strip down as a runner and to maintain and secure that level of impartiality and objectivity necessary for judging cases.
Does that mean if you were just a nominee, a private citizen as a nominee to the Supreme Court, you could answer the question, but as a judge you can't?
I think a judge is even more constrained than a nominee, but I also believe that in this process, that if one does not have a formulated view, I don't see that it improves or enhances impartiality to formulate a view, particularly in some of these difficult areas.
Thank you, Mr. Chairman. My time is up, but I'm sure the judge realizes we'll probably have to revisit this subject a tad more. Thank you.
Thank you very much. The chair recognizes Senator Kennedy for a moment regarding a clarification of a quote that was used this morning.
Thank you, Mr. Chairman. I think there was just one area of clarification. Yesterday, I questioned Judge Thomas, and I use these words. Mr. Soule goes on to suggest that employers are justified in believing that married women are less valuable as employees than married men. He says that if a woman is not willing to work overtime as often as some other workers, needs more time off for personal emergencies, then they make her less valuable as an employee or less promotable to jobs with heavier responsibilities. And then the judge went on and gave his response to that question. In a response to a question earlier this morning from Senator DeConcini, Judge Thomas said there were questions on, I think, the comment yesterday by Senator Kennedy. I believe there was something to the effect that women who were married weren't as good employees. And as an employer and someone who has employed a significant number of women, I did not find that to be true and made that very clear. I'd just like to ask consent that the record. I understood what the Judge Thomas was trying to say this morning, and I tend
to attribute Professor Soule's quotes to you.
So I just ask consent that the record reflect that modification at appropriate time. Thank you.
Yeah, without objection, the record will be corrected.
Thank you.
Senator, the senator from Pennsylvania, Senator Specter.
Chairman. Judge Thomas, coincidentally, last night after our hearings of yesterday, I had my monthly call-in show and had a lot of interest from people in my state, and some people didn't really understand the process as to what we were doing. And it might be well just to say that when questions are asked, that does not suggest in any way a disagreement with your position, but an effort to draw out how you would function if confirmed as a Supreme Court justice, and that in moving beyond your legal qualifications, we're following a practice of going into constitutional law, very much as I had said in my opening when Chief Justice Rehnquist, as a lawyer back in 1958, stated the importance of having the Judiciary Committee get into questions of equal protection of the law and due process of law. And that in the thoroughness of our efforts to find out how you would function as a Supreme Court justice, we do so because of the tremendous importance of the role of a justice, illustrated by 18 decisions last year by a 5-4 vote. And if you serve as long or to an age of Justice Thurgood Marshall, who was 83, it would put you on the court for 40 years or until the year 2031. So I make those introductory comments repetitious to some extent of what I said in my opening to give some parameter as to how I see the confirmation hearings and the importance of the separation of powers and the Senate's role in advice and consent. Because under our system of government, the President nominates, the Senate consents or not, and then the justices on the Supreme Court have the final word in so many issues of such tremendous importance. Judge Thomas, in my opening yesterday, I outlined the key focus of my concern, and that is on the very fundamental issue as to the Supreme Court's interpreting law and not making law. And there has already been considerable discussion about that subject, and you have articulated your view that the court should defer to congressional intent and should interpret law and not make law. You have dealt as chairman of EEOC with many very important Supreme Court decisions, and there are quite a number that I would like to discuss with you, but I want to start with one for illustrative purposes, and I could pick many, and that involves the case decided by the Supreme Court back in 1987, where a woman had applied for a job as a road dispatcher. There were 238 positions, all held by men. She was competing with a man named Paul Johnson. in the transportation system of Santa Clara County, which is the name of the case. Mr. Johnson had a better test score, but as part of an affirmative action program, no quotas, but affirmative action, the employer gave the job to the woman. You had commented about this case in a speech which you made in 1987, and I would like to make available to you two speeches and one article so that you can have them available during the course of my questioning. And I agree with Senator Simpson, they all ought to be a part of the record, and I would ask unanimous consent, Mr. Chairman, that they be placed in the record so that the totality of what Judge Thomas had to say in those speeches is apparent. In the course of the speech in 1987, you said this, quote, "Let me commend to you Justice Scalia's dissent, which I hope will provide guidance for lower courts and a possible majority in future decisions." The comment about guidance for lower courts we'll come back to. Perhaps it'll be for Senator Simon. He raised that preliminarily yesterday. But the point that I will focus on at the moment is Justice Scalia's dissent as possible guidance for future decisions. You then said in the article on assessing the Reagan years and the compilation by Mr. Boaz, and while you did not say that they were enough, you referred to, quote, quick fix solutions such as the appointment of another justice with the right views, close quote. You further note in the Boaz article that, quote, in each case, and now you refer to a series of them, including the Johnson decision, in each case, Congress could have reinterpreted its legislative intent to rebut the interpretation of Justice Brennan and Weber, but of course it, referring to Congress, demurred. You have commented very extensively about your view of the Congress, and I don't quarrel with your view of the Congress, except as it relates, I don't even quarrel then, I just want to find out, as to carrying out congressional intent. And in the Boaz, in a speech on April 8, 1988, a copy provided to you, you said, quote, Congress is no longer primarily a deliberative or even a lawmaking body. There is little deliberation and even less wisdom in the manner in which the legislative branch conducts business. Members act for, quote, their own interests, unquote. Quote, interests of few take precedence over interests of the many. Now, my question to you is, in a context where you think the Johnson case should be overruled, and in the context where you have articulated your regard, such as it is for Congress, and you have, well, I really don't quarrel with your view of the Congress. A lot of people have that view of the Congress. I really don't. And I think it's important to back up for just a minute on some fundamentals for a lot of people who are listening, and that is that Congress makes the law, we make public policy, and the court's supposed to interpret the law, and we all agree on those rules. And there are a lot of illustrations where Congress has overruled what the Supreme Court has done on legislative intent, where Congress doesn't like what the court has done. And I would ask unanimous consent at this point, Mr. Chairman, that a list of some 23 decisions which Congress overruled between 1982 and 1986 be inserted in the record. And we could talk about those at great length, but the point is that Congress does know how to overrule the court on matters of congressional intent. But here you have been explicit in the quick fix of judges who have the right view. You have identified the Johnson case as one where You hope that the dissent will provide the basis for a majority when judges are added. You have stated what you think of the Congress. And the question is, what assurances can you give to the Senate that you will follow congressional intent as opposed to your own public policy views on those cases?
Senator, when one is involved in the midst of a debate in the executive branch and advocating a point of view, as I alluded to earlier, one continues to advocate that point of view as an executive. When I moved to the judiciary, as I noted earlier, I ceased advocating those points of views. I think that you can have the comfort of your position, and I felt that in those cases that the congressional intent was one of non-discrimination, that was explicit in the language of the statute and clear in the language of the legislative history. That was my reading of congressional intent. Of course, the court took a different point, and those of us who may not have agreed with that point of view simply had to swallow hard and go along. I might add here that I think, and I feel very strongly, that this matter of disagreeing over what the appropriate remedies are, and this is just parenthetically, does not in any way indicate the depth of my commitment to fighting discrimination. I think it was an important disagreement as to how far you can go with your efforts to move people into the workforce that you believe should be in the workforce, who've been left out, and the effort of trying to also preserve that notion of fairness and non-discrimination that I thought was central in the statute. With respect to my disagreements with Congress, I think that those of us who were in the executive branch, and I'm certain that those who are in Congress have their disagreements with the members of the executive branch, that there is tension between the two political branches. And certainly I've had a sufficient number of oversight hearings and a sufficient number of battles to know that that tension was alive and well. But when one goes to the judiciary, I think it's important to remain neutral in those policy battles, and that is something that I've certainly attempted to do. With respect to whether or not a policy point of view or a view that I advocated as a member of the executive branch will undermine my ability to rule on cases as a judge, my answer to you, Senator, is that it will not. I advocated as an advocate, and now I rule as a judge. And I think that that is important. I think it's an important distinction. I think it is a requirement that I be impartial, and I've attempted to do that.
Well, Judge Thomas, I'm going to come to the issue of remedies, and I can understand your disagreement on oversight. Both of those are different issues, and I understand your assertion of impartiality, and I do not question it. But where you have repeatedly over such a long period of time expressed a very strong view as to congressional ineptitude, and you did that in the Fullilove case, what can one expect, quote, what can one expect of a Congress that would pass the ethnic set-aside law? And you have, again in the speech on April 8, 1988, referred to the extensive policy-making role of the court, quote, when they have made important, when referring to the courts, have made important political and social decisions in the absence of majority support, they have only exacerbated the controversies they have pronounced. If the court rules in the presence of majority support, Does that give the court any license to act? It suggests that it does. The problem I have, Judge Thomas, is that if you take a large body of your writings where you disagree with these cases and you disagree to the core with the congressional function, what assurances will we have that you will respect congressional intent?
Senator, and throughout my writings, and I can't find all the quotes now, made it clear that those difficult policy decisions, debating the large issues, are precisely the role of Congress. There may be disagreements when one is in the executive branch, but those disagreements cease, and that policy-making debates cease when one goes to the judiciary. The difficulties that I have expressed differences, particularly as one who's been involved in the oversight process, but I think I've made it clear that the legislative function of Congress, that the oversight function of Congress are very appropriate. And again, I can't go back through all the speeches, but my view would be that the court, it is the court that cannot legislate, not Congress, and that the court would be misplaced in attempting to establish policy, not Congress.
But Judge Thomas, I'm not talking to you about oversight. Now, that's the second time in response to a question about carrying out congressional intent, you've referred to the congressional oversight function. I know you had very severe disagreements, and I hope to have a chance to ask you about that later. But congressional oversight is very different from a clear-cut expression of congressional intent. We had Justice Scalia before us, and it's already been referred to, the difference in what happens on the bench as opposed to in the nomination process, and that's understandable. Justice Scalia doubts that there is any such thing as congressional intent. And when he writes about the absence of congressional response, and this is enormously important because we have the 1964 Civil Rights Act, and it was interpreted in 1971 by a unanimous Supreme Court in an opinion written by Chief Justice Burger. And Congress was satisfied with that interpretation, left it alone. And then 18 years later, the Supreme Court comes up 5-4 and changes that law, and does so with 4 Supreme Court justices who put their hands on the Bible in this room or similar rooms, swore to interpret the law, not to make new law. Justice Scalia writes in his dissent in the Johnson case that when Congress doesn't act, it could be a result of many things, including political cowardice. I think Justice Scalia might have a point, but the major area of congressional or Senate political cowardice perhaps came when we didn't ask him very many questions in his confirmation hearing. I'd be interested in your observation, or I won't ask you what you think of Justice Scalia's comment, but I'll re-ask the question that Senator Grassley put to you. When Congress doesn't act, would you agree that that's a sign that Congress doesn't think anything should be done?
Senator, I think that if there is a long-standing interpretation of a congressional legislation.
18 years long enough? Like in Ward's Cove and Griggs?
There's a long-standing interpretation and Congress does not act. That certainly would seem to be considerable evidence of Congress's intent. And it certainly would be, at least from my way of looking at a statute, evidence that cannot be ignored in revisiting that particular statute.
2 sub-questions. Number 1, is 18 years long enough?
18 years is quite a long time. I don't know whether we could put a mathematical or a numerical standard or on that, or to have that kind of a quantification as to whether or not that would be enough not to revisit a statute. But I think that when you have a statute that has been interpreted for that long a period, that is so well known that Congress is very aware of, that it would be an important consideration in finding that to be the appropriate interpretation, that Congress, the fact that Congress didn't act for such a long time.
Well, Judge Thomas, I have a problem, and I'm not saying any of this is determinative. We're just talking about your approach as a prospective justice if confirmed. But I have a problem with long enough not being enough in the context of Griggs and Ward's Co. And I have a problem with cannot be ignored, which is your word, your words, as opposed to being determinative. Seems to me that when Congress lets a unanimous Supreme Court decision stand for 18 years, that is long enough. Or if it's not, I'd like to know what is long enough. And when you talk about cannot be ignored, I would look for something more there as to a sign of what does establish what the Congress expects the court to do.
The point that I was attempting to make, Senator, was this, that when Congress doesn't act, I think it is more difficult to determine precisely why Congress doesn't act. For example, if Congress takes an explicit action and fails to change a particular statute, then that might be more evidence than simply not doing anything. But the point that, the additional point that I was attempting to make was this, that the fact that Congress did not act for 18 years is an important consideration in determining whether or not the prior ruling or the prior interpretation was the correct interpretation. It would be a part of the calculus of legislative history. I think it would be going too far to say definitively that definitely 18 years or 15 years or 10 years is the cutoff period, but I understand the point that you're making, and I don't think that a judge or a court can simply ignore the fact that Congress hasn't acted in an important area.
Judge Thomas, in my questioning you on how you handle the cases of Johnson and also the predecessors of Weber and Fullalove, we don't have time to go into all the facts now, I do so for a number of reasons. One is the one we've already examined, and the other is that you had shifted a position on it, that in 1983 you appeared to be in agreement with Fullalove and with Weber, and then your reconfirmation hearings came and you agreed to abide by them, and they relate to your approach to affirmative action and to your development of your legal thinking as you have taken the problem of discrimination and racism and how you have analyzed affirmative action, and in your career in the early 80s stated that you favored it, and then appeared to accept the Supreme Court decisions, and then later disagreed with those decisions, although you agreed to abide by them, and still later just absolutely plundered those decisions with very strong hostile comments about Congress. In your writing, Judge Thomas, you had made a very strong comment that I agree with. You said that the Dred Scott decision upholding slavery and Chief Justice Taney's opinion in that decision provide a basis for the way we think today. You wrote that in 1987. Quote, racism and discrimination are deeply rooted in the history of the United States. I agree with you about 1987 and 1991. And then there was the article by Mr. Juan Williams in the Atlantic Monthly, which sought to provide an understanding of your philosophy and your approach to programs against discrimination, and quoted you as saying this, these are the words which he says are yours, quote, there is nothing you can do to get past black skin. I don't care how educated you are, how good you are at what you do, You'll never know the same contacts or opportunities. You'll never be seen as being equal to the whites, close quote. Now, given that very strong statement, black skin, given your very strong statement about things being in 1987 like they were in the 1850s at Dred Scott, and given the fact that it's just not possible for the Equal Opportunities Commission, Equal Opportunities Employment Commission, Equal Employment Opportunities Commission to take care of all the cases one by one, why is it that you come down so strongly against any group action to try to put minorities or African Americans in the position that they would have been in as a group but for the discrimination? This is a broad subject, but let's get it started with just a few minutes to go on my time.
Senator, I think that over my years in public life as well as my adult life, I've made it clear what I think of racism and discrimination. I made it clear during my tenure as chairman of EEOC that it had to be eliminated, and I did everything within my power. I've also, even in the heat of debate, attempted to talk reason, even though I, like perhaps everyone else, was susceptible to the rhetoric in that debate. I think that we all have to do as much as possible to include members of my race, minorities, women, anyone who's excluded into our society. I believe that. I've always believed that. And I've worked to achieve that.
What's the best way to do it?
And I think that is the question, how best to do it. I think that you have a tension. You want to do that, and at the same time, you don't want to discriminate against others. You want to be fair, at the same time, you want to affirmatively include. And there's a real tension there. I wrestled with that tension. I think others wrestled with that tension. The line that I drew was a line that said that we shouldn't have preferences or goals or timetables or quotas. I drew that line personally as a policy matter, argued that, advocated that for reasons that I thought were important. One, I thought it was true to the underlying value in the statute that we be fair to everyone. And I also drew it because I felt, and I've argued over the past 20 years, and I've felt it important that whatever we do not undermine the dignity, self-esteem, and self-respect of anybody or any group that we're helping. That has been important to me, and it's been central to me. I think that all of us who were well-intentioned on either side of the debate at any given time wanted to achieve the exact same goal. I would have hoped, if I could revisit the 80s, that we could have sat down and constructively tried to hammer out a consensus way to solve what I consider a horrible problem.
But the problem I have with that response, if you take a case like Local 28 of the sheet metal workers, where the New York City Human Relations Commission cited them for discriminatory practices in 1964, and EEOC finally brought a lawsuit in 1971, and there was a finding of discrimination in 1975, and there was a court order to correct that discrimination, which there was contempt in 1977, and again in 1982, and contempt again in 1983. And you have written that you are astounded that there's more of a penalty for breaking into a mailbox than for discriminating against a minority or African Americans. And you have advocated jail sentences and heavy fines for those who are in contempt of court, and you have this kind of outrageous conduct that spans a 20-year period, and then EEOC comes in at the latter stages of this litigation in the 1980s and takes a different position and argues against the court orders to stop the flagrant discriminatory practices and the practices which have been labeled by the courts repeatedly in violation and contempt of court, and you criticize the Supreme Court's decision. They're trying to do something to deal with proved discrimination, not taking a class which wasn't discriminated against and giving them a boost forward, but in dealing with laborers who were discriminated against, judicial determinations, contempt citations, ignoring by the people who were the discriminators, and you as chairman of EEOC come in and oppose it, and then you sharply criticize the decision of the Supreme Court of the United States in upholding that kind of a remedy. That seems to me to come right within the purview of what you say ought to be done to remedy active discrimination, and yet you take the other side.
With respect to the way that that case proceeded through court, Senator, the commission itself, to my knowledge, did not approve and it was not required to approve that litigation because the general counsel had already been authorized at the lower courts to pursue that. But the point is well taken. My view with respect to cases like that has been that as a policy matter, and one that I've stated clearly on the record, is this. I think that rather than a court attempting to punish these individuals with a quota or preferential treatment, I thought that in this case and in egregious cases there could be criminal contempt citations. I felt that there should be appropriate roles for heavy fines. I think that individuals who discriminated, or I felt that individuals who discriminated against other individuals should be subject to the same kinds of fines and penalties that are available in some of the antitrust litigation. And I think that I felt that there was an undervaluation of the effects and the damage done by discrimination. And I felt that this kind of a case was very susceptible and appropriately susceptible to criminal contempt citations.
Well, I've been handed a note that my time is up, and we will return to it with my first question being, why did EEOC in your tenure join with petitioners in trying to upset the contempt citation and then taking the position that the discriminators ought not to be held for contempt and ought not to be punished? Thank you, Judge Thomas. Thank you, Mr. Chairman.
Thank you. Judge Heflin. Senator Heflin. Just so everybody didn't think it's a slip, you were a judge. I mean, Senator Heflin.
Judge Thomas, I try to approach these hearings on the basis of fairness to you, fairness to the President, fairness to your opponents, and try to consider all of the evidence before I make up my mind. I've tried to follow that procedure in the other confirmation processes, not only of the Supreme Court judges, but of all appointments to the judiciary. So I'm not at this time having a firm opinion one way or the other. I've done a good deal of reading and tried to listen to testimony, and of course there has entered into my mind from your testimony, as opposed to some of the spoken and written words that you've given in the past, an appearance of confirmation conversion. Now this term is a term that came from the mouth of my colleague Senator Leahy here in the Bork hearings, which would indicate that the confirmation process has caused one to change his mind or to give answers that won't hurt him in regards to seeking the confirmation. But it also can raise issues that can affect the evaluation that members of the committee may give as to integrity and temperament. Now, in reading some of the articles and reading speeches that you had given beforehand, most of them in about the last 5 years, or at least since you've been on the EEOC, not back when you were 20 years of age or 25 or 30, but fairly recently, there appears to be a conflict on natural law between what you have stated in the past and what you state here at these hearings. You're stating in these hearings basically that you don't think that natural law ought to be used in constitutional adjudication. Some interpretation, and it depends on how you interpret your written and spoken words beforehand, would lead to one to believe that you had previously advocated the use of natural law in constitutional adjudication. Now, natural law, of course, is a term that is broad, and there seems to be at least two schools of thought. There may be many others. One, a liberal school of thought, other, a conservative school of thought on the use of natural law. Those who are of the conservative viewpoint indicate that it would be using the Ninth Amendment, where there is no deprivation of unenumerated rights, that a judge could pick a unenumerated right, something that he said was, and then defend it under the concept of natural law. On the other hand, either from a political theory on or possible constitutional adjudication, they are those that advocate that natural law be used as a defense for judicial restraint, as being a defense for limited government, and being a defense for economic freedom and certain other freedoms. As has been pointed out, those that would advocate the natural law, and they have been those in the past in the Supreme Court decisions, particularly in the Lochner era, who say that the economic right of the freedom to contract should be allowed without any government restrictions, and therefore that minimum wage laws, health laws, safety type laws on the job are restrictions against the right to contract or the economic freedom, and therefore they follow the concept of judicial restraint, follow the concept of limited government. Now, you have been asked some questions about it, and you, of course, have very clearly come out that you don't believe that natural law ought to be used towards constitutional adjudication. And you have mentioned that you so testified in your Court of Appeals hearing. and there was quoted to you from the Court of Appeals hearing statements that you made, and this appears, and I will want you to have an opportunity later to read it, and you can give a more fuller answer after you thoroughly advise, because it's not my purpose to ambush you or to make any statement without you having a thorough right to review what you said before. But here you say, but recognizing the natural rights is a philosophical, historical context of the Constitution is not to say that I have abandoned the methodology of constitutional interpretation as used by the Supreme Court. In applying the Constitution, I think I would have to resort to the approaches that the Supreme Court has used. I would have to look at the texture of the Constitution, the structure. I would have to look at the prior Supreme Court precedents on these matters. That was what was quoted to you. The next sentence says, and this was your answer then, and as a lower court judge, I would be bound by the Supreme Court decision. Now, reading that answer, it is subject to two or more interpretations. One is that you were speaking of natural law as it would apply to your functions as a Court of the Appeals judge, and the other would be whether you would apply it as to the broad general theory of constitutional adjudication. If you want to read this and read the whole thing, I'll do it, or if you want to answer as to what, where those, it may have an appearance of either an ambiguity or either of being contradictory. If you want to, whatever you want to do, if you want to study it and read it and give me an answer later, or if you want to give me an answer now.
Let me comment on what you've said, Senator. My view is that I have been consistent. On natural law, my interest as chairman of EEOC was, as I have stated, it was as a part-time political theorist, someone who was looking for a positive way to advance the ball with respect to individual rights in our political debates, as well as on the issue of civil rights. I have not advocated or suggested that it should be used in constitutional adjudication. Our founders and our drafters did believe in natural law, in addition to whatever else philosophies they had. And I think they acted to some extent on those beliefs in drafting portions of our Constitution. For example, the concept of liberty in the 14th Amendment. I think that knowing what their views are is a context for understanding our Constitution. Knowing what they believed in is a context for understanding the separation of powers, or perhaps even understanding the notion of limited government and the rights of individuals. But when the rights are in the Constitution, then one resorts to constitutional adjudication. Now, the beliefs of the founders could be a part of the history or tradition to which we look, but you don't make an independent search of natural law, and I have not suggested that. I think my writings have made clear that natural law is the background of our Constitution, that it doesn't move to the front, and that it's not positive law. They're two separate things.
You have indicated that your writings and speeches were directed towards natural law more as a political theory, and have used the illustration dealing with slavery. How is slavery related to a political theory?
Well, the issue there was for Abraham Lincoln, how do you, when the stated ideals of our country are that all men are created equal, how do you end slavery? And what's the underpinning? What does that promote in our country? The notion that all men are created equal. So once you have the adoption of the 13th and 14th Amendments, you have a positive law. But I thought it was important to understand what that meant. It's just a notion, for example, of why do we feel strongly that apartheid is wrong? Why do we feel strongly that discrimination is wrong outside of the law? But my point is very simply that Abraham Lincoln was sitting here. I think at the time I had read the Battle Cry of Freedom, and I wondered how or what gave him the strength to survive the onslaught that he was faced with. And it was then that I began to refer back to his beliefs and the beliefs of the abolitionists as a backdrop to the Constitution, or as a background to the Constitution.
I'm going to ask that someone, staff here, hand you two documents. One is a speech by to the Federalist Society Address, University of Virginia, March the 5th, 1988, and the other being a article that appears in the 1988 Harvard Journal of Law and Public Policy titled Higher Law Background of the Privileges or Immunity Clause of the Fourth Amendment. If we will hand you that. And again, if any question that I ask, if you want to have time to read, review those, I would certainly want to do it, because I'll have another opportunity to ask you a question and where you can fully understand it. These two appear to have much relationship. The speech appears to be a speech, and then it appears that it was put in more of a law review form and was published. Is that a correct?
What you do normally with these is that you give a speech and the review edits it and converts it to a law review piece. That's essentially what happens.
All right, so now on the speech on the first page, if you look, and this is bearing in mind as to whether or not you at that time were expressing a view that higher law or natural law, as I understand it, they are used interchangeably, could be used as a part of constitutional adjudication. Now, on the speech, starting at it, you say, I appreciate this opportunity for a practitioner, the head of a law enforcement agency, to give his opinion on our subject. I do not pretend to be a legal scholar, but I have a strong practical interest in the crucial part of our conference topic, namely the grounding of our Constitution in higher or natural law. The expression unenumerated rights makes conservatives nervous, as it gladdens liberals, for the reasons our previous discussions here have indicated. I want to take a different approach to this theme, which provides necessary background for the very abstract issue of the privileges or immunity clause today. Briefly put, I argue that the best defense of limited government and the separation of powers and judicial restraints that flow from that commitment to limited government is the high law political philosophy of the Founding Fathers. Far from being a license for unlimited government and a roving judiciary, natural rights and high law arguments are the best defense of liberty and of limited government. Moreover, without recourse to higher law, we abandon our best defense of a court that is active in defending the Constitution but judicious in its restraint and moderation. Higher law is the only alternative to the willfulness of both run-amok majorities and run-amok judges. In regards to the question of higher law, how do you interpret that? It seems to me that you are advocating, or at least it has the appearance, maybe I withdraw saying it appears to me because I hadn't made up my mind, but it at least appears that that is an advocation of the use of natural law towards constitutional adjudication.
It is not, Senator. The point there is that in our regime, if you notice, I speak to the higher law political philosophy of the founders. Their philosophy was that we were all created equal and that we could be governed only by our consent, and that we ceded to the government only certain rights, and that to that extent the government had to be and was a limited government. But beyond that, and the judiciary, of course, was a part of that limited government, but in no sense, and I do not mention here or say higher law should be pointed to in adjudicating cases. It is nothing more than the background. I think I say here, it provides a necessary background. It provides us an understanding of our form and our structure in our government. It is not a methodology in constitutional analysis. I think it would have been easy enough to have said that directly.
Well, you use the word higher law is the only alternative to the willfulness of both run-amok majorities and run-amok judges. How can higher law through a political theory serve as a protection against willfulness of run-amok majorities or run-amok judges?
Well, the theory would be, Senator, essentially this, that the individual is to be protected, that the individual can only be governed by consent, so that the majority cannot take rights away from the individual that have not been conceded or have not been consented to be given to the government by that individual. It is not a notion that in your adjudication you look to this higher law. It is simply an explication or an indication that this is the theme of our underlying background political philosophy, and that the Constitution protects these rights.
All right, if you turn to page 7 and 8 of that speech, you make this statement starting at the beginning of the last sentence on page 7. Similarly, an administration inspired by higher law thinking would not have argued on behalf of Bob Jones University. The higher law background of the American Constitution, whether explicitly appealed to or not, provides the only firm basis for a just, wise, and constitutional decision. I'm taking that out of context if you want to read.
The point there was that I felt that as a policy matter, as a political branch of our government, that the administration of which I was a part made an inappropriate decision about being involved in the Bob Jones University case, a decision that had it been informed with the notion that we were all created equal, or the notion of how important it was not to have discrimination in our society, that it, not the courts, but our administration would not have made as a policy matter. I thought it was a wrong decision.
All right, so now turn to your law review article. And again, by the way, that thing that Senator Leahy was talking about, that footnote, I believe, appears here if you wanted to later, when Senator Leahy returns, it's footnote 2. But on the first page, I think basically the first part of that, you use the term run-amok majorities and run-amok judges, and in that regards. But in the context of economic freedom, or the freedom to contract, on the concept of higher law, if you were to read it in that context, moreover, without recourse to higher law, we abandon our best defense of judicial review, a judiciary active in defending the Constitution, but judicious in its restraint and moderation. Rather than being a justification for the worst type of judicial activism, higher law is the only alternative to the willfulness of both run-amok majorities and run-amok judges. In the context of economic freedom and right to contract, and the fact that any governmental restrictions placed upon those freedoms would be in effect restrictions, and could be looked upon as being run-amok majorities. Do you still maintain that that does not, and I'm just saying it's subject to an interpretation, that you are referring to constitutional adjudication there?
I am not in this sentence. Let me make a point about my interest in the economic aspect of this. I was asked, I did not just simply sit around and spend time just trying to spin theories. I had certain experiences that prompted me to think about some of these issues. And with respect to the issue of having a right to run my grandfather's business, for example, I simply looked at what, in theory, was his right. After slavery, what was his right to, or the rights of people who were near me, who lived around me, to just simply use their land and grow their food and be able to eat it or to sell it. Those were the kinds of examples that I would use. I, for example, remember vividly my grandfather, whom I thought was a strong man. And when you're small, he's a giant of a man, and certainly a man with great pride. He would literally have to get a drink before he went to the licensing bureau in Savannah to get the license that he needed to drive his oil truck. Those were the kinds of questions I was looking at. Now, I did not intend first to say that this was a basis for constitutional adjudication. I think I could have said that if I had intended that. The second point is that I have said, and I believe, that the Lochner-era cases were properly overruled, and that the health and safety, the court does not serve as a super legislature over this body or the political branches.
Well, you said you could have stated that. On the other hand, in all of these writings on natural law, you could have made the distinction, could you not, that you were speaking of a theory and not a constitutional adjudicatory process?
I think, Senator, if I were a judge, if I gave some of these speeches after I went to the bench, I would have made that distinction. But at the time, I was not a judge, and certainly did not think that at that time that it was necessary to draw that distinction when it really, at that point, wasn't relevant. I felt that, as I stated in my hearings for the Court of Appeals, that this is political theory. This is not constitutional adjudication or methodology. And I stand by that. I think it's the distinction is an important one, and it's one that certainly I didn't draw a clear and exacting line sometimes simply because I wasn't in the judiciary. I didn't say I'm not saying this or I'm not saying that, but it was not my intent at any point to provide a basis for adjudicating constitutional law cases.
You, in this article in the Harvard Journal of Law and Public Policy on page 66, this statement appears: to believe that natural rights thinking allows for arbitrary decision-making would be to misunderstand constitutional jurisprudence based on higher law. That appears, it has the appearance of advocating natural law in the field of jurisprudence and decision-making on constitutional adjudication.
Senator, no, my point is that, and jurisprudence that I would use there would be in the broadest sense, but I still take the position and took the position then that this would serve as a background to understanding what our Constitution was for. I was not speaking as a judge. I was not setting out rules of analysis or adjudication. I was trying to establish a sense among conservatives or among the audience that here is the background to our Constitution. Now, our founding fathers took bits and pieces of what they believed may have been natural law, and they placed that in the Constitution. But once it's in the Constitution, it's no longer required that anyone refer to natural law. It's a part of our positive law. And I think that that's the appropriate distinction. It's the one that I certainly attempted to make there. At no point did I intend to say, look, this is an approach or methodology for constitutional adjudication. And that was the point that I attempted to make again in my Court of Appeals confirmation. It has no role. I think that if, as a judge, I had stated, here is a new approach for constitutional adjudication, then I think you would be right, that there would be concern. But I was speaking solely as a chairman of a commission who was interested in this debate and advancing this idea, but not in adjudicating cases.
The concept that natural law is a political theory. Most political theories that are developed involve protections, adjudicatory concepts or processes. You eliminate as a part of the comprehensiveness of the natural law theory or natural law philosophy protection, rights, or the adjudicatory rights. Now, in most political theories, you would have something, if it is adopted, that would provide for protection, which is judicial decision making. Are you separating from the natural law theory adjudicatory processes?
And what I am saying, Senator, is this, that the individuals who drafted our Constitution, let's say our 14th Amendment, the abolitionists, for example, believed in natural law. And to the extent that they reduced it to a positive document, it appears in the Constitution. But one need not appeal to whatever they believed beyond the understanding what they intended to do. That the law, that our rights don't flow from what their beliefs were, but rather from the appearance of those rights in the Constitution.
Well, if it became the positivism, the positive law of the Constitution, then why is natural law being advocated? The concept that if it is constitutional law, if natural law has progressed to the extent that it is positivism, it is a part of the Constitution, then why all of the great discussion today on natural law?
Well, for me, it was just a matter of discussing an understanding of the issue of slavery and the issue of the underlying values and the underlying ideals of our country. I thought it was important. I thought it was a way of discussing an issue that was important to me, rather than in simply constantly arguing about goals and timetables and quotas. It was a way of attempting to find a way to a theme to unify us on this debate, and a way to convince individuals whom I felt should be supportive of civil rights. And I'm not saying that it worked, and I certainly never thought that I would be having this discussion about it, and I did not intend it certainly as a method of adjudication.
Well, let me ask you this last question. I understand my time's about up. How does natural law, as a political theory, provide protection for limited government or for judicial restraint if that political theory excludes constitutional adjudication?
I think Senator, it offers an understanding of why it was necessary, or why our founding fathers felt that we should have a government that did not infringe on the rights of individuals, or a government by consent, rather than our rights emanating from that government. It gives us an understanding of why government ought to be limited, why it ought not to intrude on the individual, why there is a line between the individual and the government. It gives us a sense of why the government shouldn't require that black people live over here or white people live over there, but it doesn't adjudicate it. It gives us an understanding of why slavery was wrong, but it doesn't provide for the manumission of slaves. That had to be done by the Constitution. And again, it is theory. It was an endeavor that I thought was an appropriate endeavor at that point in my career. I did not intend for it to involve constitutional adjudication.
Thank you. Before we take a break, just out of curiosity, you keep talking about the need to get conservatives to be more supportive of civil rights. Does that mean they are not supportive of civil rights? I'm not being facetious, and because it goes to the question of your intentions here. Are conservatives supportive of civil rights?
I was giving them reason to be strongly supportive and more aggressively supportive of civil rights. I don't think they were necessarily against civil rights, but I thought that there was a comfort level in being opposed to quotas and affirmative action. And I thought that we should advance the ball, that the issue of race has to be solved in this country, and that we have to stop yelling at each other, and we have to stop criticizing each other and calling each other names. And I was involved in that debate, and I was a pretty tough debater too. But at some point, we've got to solve these problems out here.
I think the State Department's the place for you, Judge. I will recess to give you a little bit of a chance to have a break for 10 minutes.
All right. So this was confirmation day 2, part 3. Lord. Day 2, part 4 would be the last part of today. I mean, I feel like we're committed here. And we don't need the rabble, the South Park rat. And this isn't even turned all the way. Oh, there it is. Rabble.
Chairman, that this substance of the... Thank you, Mr. Chairman. Judge Thomas, I've heard a number of criticisms of the chairman's style of conducting this hearing. The substance of those criticisms have evolved around the fact that he clearly is too soft on you, has not brought the tough questions out. And I just wanted to serve notice on the chairman that this love-in that he seems to be presiding over will come to an end. Reflecting on my own children, I have 2 daughters and a son. It's clear to me that if I want to get the inside information on my son, I ask one of his sisters, and we intend to call your sister as a witness later on, whenever the chairman will allow that measure. I don't know if that's...
You just scared the living devil out of him. He's not sure whether you're serious. You see the look in his face. He's only kidding, Judge.
And if you call my brother.
I think we can make arrangements for that.
Okay.
Clarence's sister there and not his daughter, and I believe I said that, so want to get all this sibling stuff straightened out. Thank you, thank you.
As far as his sister's concerned, she'd rather not be corrected.
Yeah.
Rather be a daughter.
Judge,
Things got weird.
earlier in this hearing, you were asked about the right to privacy, and as I recall your answer, you indicated that you recognized a right of privacy within the Constitution. Since that is one of the cornerstones that leads to decisions involving Roe v. Wade, I think that was of some real significance and interest to this committee. You've been asked specifically about Roe v. Wade, and you have declined to answer on the grounds that you may well be called upon to rule on those specific issues as a judge of the court. I'd like to ask a related question that's slightly different. I can understand the reluctance to indicate how you would rule, but I would be interested to know if, in your own mind, you have come to a decision on the right to terminate a pregnancy. I'm not asking what that decision is, but I'd like to know within your own mind if you have come, if you're at a point where you've decided that.
Senator, I think that, as I've noted earlier, that for me to begin to state positions on either personal or otherwise on such an important and controversial area where there are very, very strong views on both sides would undermine my impartiality and really compromise my objectivity. And I think that it's most important for me to remain open. I have no agenda. I'm open about that important case. And I work to be open and impartial in all the cases on which I've said. I can say on that issue and on those cases, I have no agenda. I have an open mind, and I can function strongly as a judge.
Well, I thank you. I think that the willingness to look at the facts and review them objectively is an important factor for us to look at. Mr. Chairman, I think it's appropriate here to at least to put into the record something that was said by Justice Marshall upon his confirmation. He was asked by a variety of senators to indicate how he would have ruled on a number of cases. The Miranda case was brought up, as well as several others. In the Miranda case, or at least in response to the Miranda case, Justice Marshall said this, and I quote, "I am not saying whether I disagree with Miranda or not, because I'm going to be called to pass upon it. There is no question about it, Senator. These cases are coming to the Supreme Court." Justice Marshall remarked at a different stage of the hearings, quote, "My position is, which in every hearing I have gone over is the same, that a person who is up for confirmation for justice of the Supreme Court deems it inappropriate to comment on matters which will come before him as a justice." I thought it's appropriate to have that in the record. The position you've taken with regard to announcing an opinion in advance of hearing the case is certainly in line with other people who've been advanced to the Supreme Court, in this case specifically Justice Marshall. But I must say I do appreciate your answer to my question. I think a critical issue for us here is to know that you're willing to listen to the facts in those cases.
If the Senator will yield, do you want more of the record? Did you have more than you read that you want to place in the record?
I think I would leave it at that, Mr. Chairman.
And secondly, did the witness answer your question? I didn't think he answered your question. That is, did he make up his mind? Not what is it, but just has he made up his mind?
I indicated that it would be inappropriate to explain to him or to say whether I did or not.
Okay, thank you.
At least my interpretation, and I appreciate the chairman mentioning this, at least my understanding was that the judge indicated that his mind was, he was willing to listen to the facts on this, and his mind was open in terms of this particular case.
That's correct.
I'm assuming that you have not made a final decision in your own mind on the Roe v. Wade case.
That's right.
Thank you. Earlier, the chairman had brought up, I thought, some very important questions involving economic rights in the Constitution. I know you commented further on that and answered Senator Hatch's question specifically with regard to several lines of questions or several lines of cases that I know our chairman was concerned about. In addition, you had commented with regard to whether or not you would be a disciple of several philosophers that were mentioned, indicating that you would not. I'd like your views, though, on a different aspect of this economic question. As I just glanced through the Constitution, we have a variety of provisions of the Constitution that deal specifically with property rights. Articles 1, 4, 6, Amendments 2, 3, 4, 5, 7, 13, I suspect many others. These are property rights, economic rights, if you will, that are specifically addressed in the Constitution and protection provided. It's been suggested, I think, by the chairman, or at least an observation, perhaps I should say, by the chairman, that in the past some Supreme Court cases have accorded property rights or economic rights a lesser degree of protection than other rights in the Constitution. My own view of it is that it's very difficult to separate rights. It strikes me that if someone cuts off your salary because you've said something, that you may have denied freedom of speech, but you've done it through a deprival of economic rights, of property rights. At least it occurs to me that if the 13th Amendment means anything, it means that you have a justifiable property rights in the fruits of your labor. And if you're not going to protect the property rights of your labor, the 13th Amendment doesn't mean much. Now, I broach this subject because I think it's important. In my mind, it's difficult to separate property rights and personal rights. It does appear to me that both are protected in the Constitution, and I guess I would like an indication from you as to whether or not you think property rights deserve a lesser protection in the Constitution, greater protection under the Constitution than other rights, or whether it's a balancing between rights when these questions arise. Would you share with us your view on that?
Senator, my point has been that property rights, of course, deserve some protection. And I think they're, as are our other rights, important rights. The courts, in looking at the economic regulations of our economy and our society, has attempted to move away from certainly the Lochner era cases and not act as a super legislature. And I indicated that that's appropriate, particularly in the area, as I've noted, on the health and welfare, wage and hour cases. I think that some of those cases, the area, I think there's some development in the taking area, and perhaps if I'm fortunate enough to be confirmed to the court, that perhaps I would be called upon to rule on those issues. But I would be concerned about the diminishment or the diminution of any rights in our society. But that is not to say in any way that I disagree with the standards that the court applies to protecting those rights today.
Thank you. I wanted to address the subject of stare decisis. It's been raised by other members of this committee. I think the distinguished senator from Ohio has discussed it, concern about overturning of previous decisions and precedents. As I see the figures, from 1810 through 1953, we had a total of 88 cases that were overruled, where a previous decision of the court was simply and flatly overruled by the court. That's 88 cases in 143 years. Interestingly, I think in the next 37 years, we had 112 cases overruled. Really starting with the Warren Court on, you had a much greater movement on the part of the court to overrule previous decisions. I mention that because apparently the modern courts, at least since the Warren Court, have been much more inclined to move in that direction, not less so, in terms of observing stare decisis. But at least I observed those cases as ones that were important landmarks. Brown versus the Board of Education, addressing segregation. Mapp versus Ohio on a legal search. The Gideon case involving the right to counsel. These are areas where we've overturned precedent, but I think to a very significant and real reason behind those changes. I mention all of this because I wish you would share your view with us as to the kind of standards you're going to use in sitting on the court as to whether or not you'll choose to overrule a previous decision of the court. What kind of standards are you going to be looking to apply?
Senator, I think that the principle of stare decisis, the concept of stare decisis, is an important link in our system of deciding cases, in our system of judicial jurisprudence. The reason I think it is important is this. We've got to have continuity if there's going to be any reliance on, if there's going to be any change in our case law. I think that the first point in any revisiting of a case is that the case be wrongly decided, that one think it is incorrect. But more than that is necessary before one can rethink it or attempt to reconsider it. And I think that the burden is on the individual or on the judge or the justice who thinks that a precedent should be overruled to demonstrate more than its mere incorrectness. And at least one factor that would weigh against overruling a precedent would be the development of institutions as a result of a prior precedent having been in place. But again, I think it's the first step is that the precedent be incorrect, and the second step in the analysis has to be more than the mere incorrectness of that precedent.
I'm wondering if the standards that you will be applying will vary depending on the constitutional issues involved. Is this a standard you'd apply in every area?
I think, Senator, that the standards that I gave you should be as uniform as possible. I don't think, for example, as I've read someplace, that the standard should be less for individual rights than for commercial cases. I did not understand that comment, but it would seem to me that individual rights deserve, or the cases in the individual rights area deserve the greatest protection. and should be considered with the application of the highest standards of stare decisis.
Thank you. I want to change subjects on you for a moment and take you back to the EEOC during that 8-year period that you directed that agency commission. My recollection is that in 1983 you changed policy for the commission, that the commission adopted a resolution to shift its presumption in favor of rapid charge processing to one of a case-by-case investigation. I wonder if you would be willing to outline for us this policy initiative, and if you would relate what kind of results it achieved or didn't achieve, what kind of changes occurred.
Senator, when I arrived at EEOC in 1982, among the many problems that I incurred, and indeed there were many, was that the existence of a rapid charge system. That system was designed to reduce the backlog that had plagued EEOC for so many difficult years. I felt that the system, which in essence brought the charging party, filed the claim of discrimination, and the employer together and required them to reach a settlement without investigating and determining whether or not there was actual discrimination. I felt that that system shortchanged both parties. The Commission voted in the policy that as an ideal, felt that or indicated that cases should be investigated as fully as possible before there's any determination. That took quite some time to implement, but the sense of it was this, that if someone, and there were approximately 60,000 charges filed a year, if someone filed a charge, that person had the right to have it investigated and to have a determination made as to whether or not there was discrimination. One of the results of this approach is the increased number of cases that were litigated. And I think also an important result was that we were more consistent and I think more faithful to the statute that required us to investigate these charges. Again, this effort was not without its glitches, but I think it was a very important move in the right direction and brought about the appropriate results for an agency that enforces non-discrimination laws.
Thank you. One of the changes that I have understood that you have focused on during that period was an effort to automate the office, adopt computers and computer systems. I wonder if you could summarize what you did and whether or not you thought it was a wise investment.
Again, Senator, we automated in a number of ways. The first area that I was told when I was confirmed that I had to clean up was the financial management area. The then chairman of the Labor and Human Resources Committee told me that he would call me on the carpet if that was not done. We were able to automate that area and as a result achieve savings that we could then use to automate other areas. And the net necessity for automating is quite simply that when you receive 60,000 charges a year in 50 offices across the country, in order to manage and in order to understand your agency and in order to be able to understand the type of discrimination that's taking place in the society, you have to have a database. You have to have a database in each of the offices, and you have to have a national database to manage that national workload from the central office here in Washington, D.C. One of the problems that you have when you don't have that database is simply you don't know what's going on in the agency. You don't know what changes there are, and quite frankly, you have no idea what's in your workload except the most general of ideas. Without additional resources and over a period of time, we were able to build a database, to put the automated management systems in the offices across the country, and as well as develop a national database that is so important in managing our workload and actually enforcing the equal employment opportunity laws.
Thank you. Judge, I must say I was shocked at hearing comments that you had made about Congress. Those harsh views are ones, of course, we've never heard before. And as one who came to Congress some 11 years ago with the thought that we would balance a budget within a couple years, the concept that perhaps a $250 to $300 billion deficit a year leaves something to be desired, I suspect is not new to the American people. But sometimes seeing the emperor has no clothes is not always the greatest help for you in the confirmation process. Be that as may, I think the underlying question is an appropriate one. And that is, what will your attitude be as a justice of the Supreme Court in reviewing the constitutionality of legislation in which you find yourself in disagreement with the policy judgments of Congress? Are you going to be able to separate out your objections to congressional policy in making a determination of whether or not that law is judged constitutional?
Senator, I think it's one thing to be in the executive branch and to come back and forth to oversight hearings and budget hearings and to disagree on policy decisions and to argue and debate and advocate for a particular point of view. There is a tension there. And sometimes those of us who have been nominated and needed to be confirmed have had deep regret about negative comments about this body or anybody. But the appropriate role for a judge totally precludes being a part of that tension and that debate and that advocacy. A judge must determine what the will of this body is. A judge doesn't have to agree. A judge doesn't have to think it's the most wonderful legislation in the world. Indeed, that's irrelevant. The judge's role is to, as impartially as possible, to determine what the will of this body is. And that's precisely what I've attempted to do in my current position as a judge on the U.S. Court of Appeals for the D.C. Circuit, and never to supplant my personal views. As I indicated earlier, when I pick up a case for consideration, the first question I ask myself is, what is my role as a judge in this case? And that role never includes bringing personal views or predilections to that case.
I appreciate that. I expect that is not the easiest portion of your duties or task, or it would not be for me. You've mentioned several times in the course of these hearings your experiences in dealing with congressional inquiries involved in the various agencies you've either directed or been involved in. My understanding that you've appeared in response some 57 times in addition to the, I guess, the 5 times you've been up for confirmation. I wonder if you'd give us an idea in those 57 inquiries, how much time was involved, what it involved on your part, your agency's part in terms of staff time, commitment, resources.
Well, I would have to, Senator, to put that inquiry into 2 separate categories. The least amount of involvement are the instances in which there's significant cooperation between the staff of a particular committee and the agency. The difficulty arises when there is, in the second category, significant disagreements or where there's significant information or document requests involved. But as a rule of thumb, when I prepared for a hearing, any of the hearings other than my own confirmation hearings, I would allow a minimum of 4 to 8 hours of personal preparation in addition to whatever time or staff time it took to gather documents and to address the issues that concern the committee involved.
What about the agencies itself?
The involvement of the agency, again, depends on the range of the inquiry. There have been instances when the involvement has been quite overwhelming as a result of the amount of data involved. And generally, however, the agency's involvement has been, though sometimes exacting, it's been within manageable ranges.
Judge, in the past, you've expressed some concerns about racial quotas. And if I understand your position as it's been articulated at this hearing, it's been an interest or an advocacy of affirmative action, but an opposition to racial quotas as a method of achieving those advances. I wonder if you could articulate the differences you see and the reasons for them.
As I indicated earlier, Senator, throughout my adult life, I have advocated the inclusion of those who have been excluded. I've been a strong advocate of that. I advocated that in college, and I advocated that in my adult life. And I certainly practiced that during my tenure at EEOC. I felt, for example, that there were many opportunities to include minorities and women and individuals with disabilities in our workforce. And I took every occasion to do that. In the Senior Executive Service Program, the top level of government managers, our record is superb. The efforts that I was able to achieve in agreements, scholarships for minorities and women across the country, colleges and universities, programs, internship programs, mentor programs, stay-in-school programs, etc. And I think that many of us of goodwill and many of us who, though we don't necessarily share the same approach, agree with that goal, that we have to include individuals who've been left out for so long. The difficulty comes, how far do you go without being unfair to others who have not discriminated, unfair to the person who's excluded? And at that range, I thought, and again, this was the policy position that I advocated, that it was appropriate to draw the line at preferences and goals and timetables and quotas. I also felt that those approaches, the objectionable approaches, had their own consequences. And that is, I felt that they had the tendency of undermining the self-esteem and dignity of the recipients. That is, again, something that others can debate, but I thought it was a valid point of view, and that those approaches, if we went too far, actually could be harmful to the very individuals whom we all care so much about. But I am very firmly for programs to include those who have been excluded. That has been a passion of mine throughout my adult life.
In describing your views on racial quotas, unless I've missed it, you have not anchored them based on constitutional arguments, but anchored them in your own feelings about what makes sense, and, what makes reason. And I know there's the Plessy versus Ferguson dissent that you've referred to, or at least it's been attributed to you that you found some interest in Justice Harlan's dissent there in that case. includes this quote, "But in view of the Constitution, in the eye of the law, there is in this country no superior, dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law." Now, my recollection is I did finish saying I understand your reluctance to rule on cases in advance. But do you attribute your concern over racial quotas to a reading of the Constitution as well?
I think, Senator, in the appropriate circumstances, we all are concerned with the underlying value of fairness that is expressed in our Constitution as well as in our statutes. But I'd like to make one comment with respect to that quote, and I think it's an important comment, that we have to remember that even though the Constitution is colorblind, our society is not, and that we will continue to have that tension.
Thank you. Judge Thomas, I bring this subject up not to cause you personal concern, but because it's become part of the debate over your nomination. I preface that way because it is not normally the type of thing that I guess I would bring up at a hearing of this kind. But one of the charges that has been brought against you in this nominating process is that you benefited by quotas or affirmative action, but do not support them. I guess the question is directly in entry to Yale. Were you part of an affirmative action quota? Were you part of a racial quota in terms of entering that law school?
Senator, I have not during my adult life or during my academic career been a part of any quota. The effort on the part of Yale during my years there was to reach out and open its doors to minorities whom it felt were qualified. And I took them at their word on that. And I have advocated that very kind of affirmative action. And I've done the exact same thing during my tenure at EEOC. And I would continue to advocate that throughout my life.
Mr. Chairman, my time is up. I would merely note for the record that the judge was an honors graduate of Holy Cross, his undergraduate school, and asked that we admit to the record an article on this subject from the Daily Journal.
Without objection. Now, suspend just for a moment. I was just conferring with staff about the timing, Judge, so you have a sense of how much longer you're going to sit there. It is a quarter of now. I think what we should do is we'll go with one more senator. We'll go with the senator from Illinois, and then we will take up tomorrow morning at 10 o'clock with the senator from Wisconsin, followed by a second round beginning with me. Senator from Illinois. Senator Simon.
Judge Thomas, in order to avoid doing what Senator Danforth said we shouldn't do and just read little snippets from what you have written and said, I have read now over 800 pages of Clarence Thomas's speeches, opinions. I have read more of Clarence Thomas than any author I have read this year. I regret to say I don't think you have a bestseller in the works. But it is important because when you say you have no agenda, or when you say you are not a policymaker, the reality is you become a policymaker on the United States Supreme Court. And if I may quote from Justice Frankfurter, it is the justices who make the meaning, talking about the law and the Constitution. They read into the neutral language of the Constitution their own economic and social views. Let us face the fact that 5 justices of the Supreme Court are molders of policy rather than the impersonal vehicles of revealed truth. If, for example, in this committee, my colleague Senator Heflin and Senator Hatch have a disagreement and work out a compromise, and the law is not completely clear, then ultimately you may have to decide and make policy. That may be a 5-4 decision of the court. And I mention this because generally, while it is not always true, generally you can tell where a justice of the court is going to go by looking at his record. And if, for example, Justice Marshall has been talked about here, generally we can say there were no great surprises in Thurgood Marshall's record on the court because we knew where he had been. And when I look at the writings that you have had, I find a somewhat different tone, frankly, than the response to questions here, or somewhat different, with great respect to my colleague, Senator Danforth, who gave as strong and eloquent an endorsement as I have ever heard of any candidate. But what I read is somewhat different from the tone of the remarks, the quotes that he made there. And when I read attacks on minimum wage, for example, and on that I would, your sister and mother have been mentioned already here, I would defer to your sister and mother on whether or not we ought to have a minimum wage law rather than to Judge Thomas. Or when I read and when I hear you mention the public housing that your mother was able to move to, and then I read your statement, and I have I have 16 similar in tone here, but let me read the one that I read in the opening statement. I, for one, don't see how the government can be compassionate. Only people can be compassionate, and then only with their own money, their own property, and their own effort, not that of others. Now, in the case of public housing, my feeling is we're talking about government being compassionate. And we're talking about government being compassionate, taking a little of your money, taking a little of Jack Danforth's money, taking a little of my money, but doing something that is very constructive and very needed. I find an inconsistency there, and well, let me just ask you to comment on what I see as an inconsistency and maybe you do not see as an inconsistency.
Senator, with respect to, let me just address the minimum wage. The concerns that I raised in a policy debate was something that I felt should have been taken into account. I think we are all for a decent wage. The one factor that I thought should be taken into account is the impact it would have, particularly on minority teenage employment. And if that was considered in the calculus, then that was fine. But that was an important consideration. That is a policy decision. It's not one that judges make. And with respect to public housing or comments about compassion, I don't think in all of those that you found one word saying that we shouldn't spend money to help people who are poor or downtrodden.
Doesn't that what you're...
I think that we have an obligation to help those who are down and out. That is what I tried to point to in my opening statement, that as a part of our community, I think it's important for us to be willing to pay taxes so that people have a place to live.
And so when you attack, for example, redistribution of wealth, in one statement I read, could have been made by an early king of France, very negative on the redistribution of wealth. But in fact, when we have public housing,
I think that's very important.
And that does not offend you?
No.
All right.
The only, Senator, let me make one point. I think that it is important that we recognize, whether we have public housing or any other policies, that we make sure that we are doing good for people who are the beneficiaries or recipients of this. Years ago, I think we remember that there were public housings in certain cities that ultimately had to be torn down because they turned out to be more harmful to the inhabitants than they were helpful.
In St. Louis that you all three of us know about here.
The debates that I requested and would have hoped to have been a part of is, look, let's re-examine the pros and cons. Let's have a constructive debate about it. The problem's still going to be there. I call the debate over affirmative action a pointless debate, because at the end of the day, there are people who are still not a part of our economy. We can agree or disagree all day. It's as though we're fiddling while their chances burn. So I do think that those efforts are important, Senator.
And if in that connection, affirmative action, Senator Brown just asked you about college programs. One of your successors in the Office of Civil Rights in the Department of Education has criticized setting aside scholarships for minorities. Washington University, headed by a distinguished chancellor, William Danforth, has graduate fellowships for minorities in the field of science and math. Does that offend you in any way?
It's my understanding, Senator, that there may be litigation about that particular policy, but let me answer that in this way. When I had the opportunity to establish a program at EEOC that provided scholarships for minorities and women, I did. And it is a program that I think now has about $10 million in endowments. When I had an opportunity to establish a program or to participate in the establishment of a program here in Washington for minority interns, I did. I think that it's important for them to be here, to participate in this process, to learn from this process, to grow. I wish that when I was a kid that I'd had this opportunity also. So I think that there are steps that need to be taken. But I can't on that specific policy. I think it would be best that I not comment explicitly on that.
That's a perfectly legitimate response. Again, so that I can get a feel of where you're coming from to judge where you're going to be going. Newsday magazine describes James J. Parker as a mentor and the person who introduced you to the Reagan White House. Is that an accurate description?
Jay Parker has been a friend since I worked here on Capitol Hill. He was not the person who introduced me to the White House.
Okay. He has been for many years, a lobbyist for the government of South Africa. Were you aware of that?
I became aware of that, interestingly. Even though he's a friend, I can tell you that I do not question, he's an honest individual, and I didn't question him about his personal activities and his businesses. I became aware that he through the news media as you did about this particular activity.
Now, he is quoted at one point in saying he informed you in 1981 about that. You don't recall that?
I don't recall it. I knew he represented some of the homelands in South Africa at some point. And I think the Mandela family or some individuals in South Africa. I was not aware, again, of the representation of South Africa itself.
He and a fellow named William Keyes, who are both editors of Lincoln Review, which is frequently given a far-right label, whether it's justified or not, is frequently given that label. But the two of them, over the course of the years, received well over $1 million from the government of South Africa. They also, in editing this publication, have had a number of articles critical of sanctions, anti-choice articles, other things. For 10 years, you were an editorial advisor to that publication. Did you at any point question whether these articles that while critical of apartheid, were in agreement with the policies of the government of South Africa, or also the anti-choice articles? Did you at any point suggest that those were not proper?
Senator, the role of a member of the advisory board was purely honorary. There were no meetings, there was no review of literature, there were no communications, there was no selection of the material that was included in the journal. Indeed, I don't think that I've read a copy of the Lincoln Review in 2 or 3 years, and I haven't received one in the mail in the last 2 or 3 years. On the issue of South Africa, however, let me make this point, that even as I was aware of Mr. Keyes' involvement with South Africa. I was not aware of Mr. Parker's. But even as they took that position, I took a strong position on the Board of Trustees of Holy Cross that we divest of stocks in South Africa. That was important to me then, and of course that's contrary to a position that they might take, but it's one that I felt strongly about.
I was not Clarence Pendleton and Stephen Rhodes in criticizing those who were protesting at the South African embassy, South African policy. At least this is a Washington Post reports this. Did you do this on your own? Were you requested by someone to do this? Do you recall this?
I have no recollection of that at all, Senator.
Well, I don't know. Somebody give that. If you can just look at the article and see if you do recall this.
Thank you. I think the quote that if these were protests about the quality of education black kids in the United States receive, about the high crime rate in black neighborhoods, I would be right out front in that kind of a march, is probably the kind of statement I would have made.
But the three of you did this in a coordinated way. Obviously, you know, it didn't just happen that all three of you said that the same day.
Well, the only way that I think that something like that could happen would be that we were called the same day by the reporter. I had no involvement on that issue within the administration.
Do you know what we're here for? You know,
I would assume that the reporter simply picked up the phone and looked for individuals to get a comment.
All right. If on further reflection you or anyone else has any further background on that when we get around the second
I simply don't remember a coordination. If anything comes to mind, or if I can reflect on that, I will certainly apprise you of it.
On the question of privacy, you have been critical of the use of the Ninth Amendment. And when you were asked by Senator Metzenbaum, I believe, about the question of privacy, you referred to the 14th Amendment. There are at least 3 members of the Supreme Court who have referred to the right of privacy as a fundamental right. The Ninth Amendment, as I'm sure you're aware, grew out of correspondence between Madison and Hamilton, where Hamilton said, if you have a Bill of Rights, some people will say these are the only rights people have. And so the Ninth Amendment was added, which says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. That is not just in isolation there. In the Constitution, you also have provision you can't have a search into your home without a search warrant. That is, in a sense, a right of privacy. The Constitution says you can't have militia quartered in your home. That is, in a sense, a right of privacy. When you put that all together with the Ninth Amendment, it seems to me that there is fairly clearly a right of privacy implied. Now, that becomes significant because if you use the 14th Amendment as a basis for the right of privacy, that comes later in our history then. It has not been a part of our whole, of the tradition of our country to have a right of privacy. Do you have any reactions to that? And do you consider the right of privacy a fundamental right?
Senator, to my knowledge, the Supreme Court, no majority has used the Ninth Amendment to establish as a basis for a right. Of course, it was used by Justice Goldberg and by Justice Douglas in Griswold. With respect to the approach that I indicated that I thought was the better approach, it was Justice Harlan's approach. But with that said, my bottom line was that I felt that there was a right to privacy in the Constitution, and that the marital right to privacy, of course, is at the core of that, and that the marital right to privacy, in my view, and certainly the view of the court, is that it is a fundamental right.
Let me shift to another area, and that is the church-state area, where you have not written very much, and where, in fact, the only thing I have is where you were in response to a question about religion in the schools in Policy Review magazine. You say, and your mother is quoted here now, my mother says that when they took God out of the schools went to hell. She may be right. Religion is certainly a source of positive values, and we need all the positive values in the schools that we can get. It's the only thing I have found in this whole church-state area. This is an area where, again and again, during your years on the court, you will be asked to make decisions. Since 1971, the court has followed a 3-part Lemon criteria that you may be familiar with, those 3 questions, because it is a complicated area. It is Jefferson's wall of separation. It's not quite that clear. Then when the Methodist Church is on fire, you call the fire department. You don't say separation of church and state, we can't put out the fire. because of a number of factors. But the Lemon criteria are, number one, does it have a secular purpose? Number two, is its effect to advance or inhibit religion? And number three, does it excessively entangle government and religion? That's what the courts have been using, the Supreme Court has been using since 1971. I guess I have a twofold question. Number one, are you familiar with the Lemon criteria? And second, if you are, do you think they are reasonable criteria that should be used in the future?
Yes, Senator, I am aware of the tests enunciated in Lemon v. Kurtzman. The court has applied the test with some degree, I think, of difficulty over the years. I have no personal disagreement with the test, but I say that recognizing how difficult it has been for the court to address just the kind of problem that you pointed out when the church is on fire, or when there is this closeness between the activity of the government and the activity of the church. And I think the wall of separation is an appropriate metaphor. I think we all believe that we would like to keep the government out of our beliefs, and we would want to keep a separation between our religious lives and the government. But the court has had a great deal of difficulty, and there's some debate on the court as to how far you should go, whether or not there should be this complete separation, whether or not there should be some accommodation in certain circumstances, or whether or not even there should be a movement as far as just simply to the position where the government isn't establishing a religion or coercing individuals to be involved in a certain kind of activity. But I think it's a vibrant debate. I do have an open mind with respect to the debate over the application of the Lemon v. Kurtzman test, and I recognize that the court has applied it with some degree of difficulty. But at the same time, I'm sensitive to our desire in this country to keep government and religion separated, flawed as it may be, by that wall of that Jeffersonian wall of separation.
Let me give you a very specific instance that you're not going to be confronted with, though the issue may be one that you will be confronted with. We have a House colleague by the name of Dan Glickman, a congressman from Kansas. He told me the story, and I repeat it with his permission. When he was in I think it was the 4th grade, they had prayer in the schools in Wichita. He happens to be Jewish. The large majority of the population in Wichita is not. Every morning when he was in the 4th grade, he was excused while they had school prayer, and then he was brought back in. Every morning, little Danny Glickman was being told, "You're different." And all the other 4th graders were being told he was different. Does this strike you as something that is offensive in terms of where we have been, where we ought to go?
Senator, I think that when we engage in conduct such as that, when someone feels that he or she is excluded because of certain practices, such as those religious practices, I think we need to question whether or not government's involved. I think it's wrong. You know, as you were talking, something came to mind. I remember being excluded from conversations about the War of Northern Aggression, which, for those who don't know about the War of Northern Aggression, is the Civil War, and it's refought, and for those who think it ended at some point. But it is a sense of exclusion. And for those of us who have felt that sense of exclusion, I think that we have a strong sense that any policy that endorses that exclusion, and I think Justice O'Connor points that out, should be considered inappropriate. And my concern would be with someone like Danny Glickman, that when we consider cases in a constitutional context, that we understand the effects of government perceived endorsement of one religion over another, and that we take that into consideration when we analyze those cases.
Have you, I don't think since you've been on the appellate court you've had any chance to rule on any of these church-state issues, to my knowledge, have you?
In my way of recollection or my knowledge, I have not, Senator.
If you or anyone in your, Ken or Fred or anyone can, if you have written anything in this field, I would be interested in seeing it.
I think my writings in this area are mercifully minor, if any.
My time is just about up, and rather than start the next subject, when you're the last in line, you have to skip from subject to subject, whatever hasn't been covered. I will hold off until the second round. Thank you very much, Judge. Thank you, Mr. Chairman.
Senator, all the writings in the area of natural law, there aren't any religions. Senator, I understand that you don't mind if we start tomorrow. Senator Cole, do you? With you tomorrow? Tomorrow we'll start at 10 o'clock, Judge. I'm going to give you a copy, which you already have, of some of your speeches that occurred post-84, I believe, almost all of which have been discussed, but just so you have copies of them, because I'm going to ask you tomorrow to help me understand some of them. And if there is no further business to come, I've been asked, in order to accommodate the President's request to continue to allow district court and circuit court judges to be reported out during this process, that we will have a very brief, which will make no sense to anyone except White House staff that's here and the committee, a very brief exec tomorrow to vote on reporting out, how many? 13 federal judges and 4 U.S. attorneys. And so as a practical matter, I say to the press, we're wondering exactly when we're going to start with the questioning. It could probably be closer to 10:30 than 10, but the purpose of that is to report out these federal judges because we serve, and we'll do it right here. We might as well just do it right here so we don't have to move around. And so we will, but we're going to try to start as close to 10, Judge, as we can with you. This exec won't take very long. And with that, no further business coming before the committee this evening. We'll adjourn until 10 a.m.
And we'll start around the same time tomorrow. That'll be day 3, part 1. Joe Biden looking old back in 91. We had some great, the feds like to pop in once in a while. We had some really good conversations, and they weren't one-sided. They were really good conversations in the chat. I really appreciate it. Yeah, and Thomas had some good questions, and they let him answer, and he answered them. It's almost like we don't see that. It blows our minds today seeing someone come before a congressional hearing and actually answer questions. You know, I will say that the SCOTUS hearings, and you look at Kavanaugh too, there is a little bit more decorum than other hearings that are more contentious. Say oversight hearings become very contentious. Now SCOTUS hearings become very contentious too. And we haven't even heard, I don't think Anita Hill's name has come up yet, and I know a lot of people are waiting for that. That really stole the show. I wasn't paying attention to 91, so I'm interested to see how this comes out as it came out. These are days and days of hearings. Scalia had 2 days of hearings. This is like something like 11 days, possibly, all told. Many parts per day. So it's interesting. The issues that came up. Let's see. Someone asked, and the judicial philosophy between the Constitution and natural laws come up a lot, and every time it's come up, Thomas has said, I basically subscribe to the four corners of the Constitution. The natural law thing is just something I talked about, once or twice. Roe versus Wade, abortion, the baby's life came up. And we spun that into our own conversation, Chad. I appreciate it. And Thomas's position, if I'm not mistaken, was, he back in '91 there wasn't a lot of case law that had developed around whether or not, an unborn baby has rights, right? And now there is. There's been the laws that will come up if you look for them. A lot of the times have to do with, unfortunately, the mother succumbs to her injuries. Maybe she's murdered. Something else happens, and she's pregnant. And does the person responsible for the death, are they responsible for more than one death? Let's say. It's not something that comes up in this debate a lot. A lot of the crazy stuff comes up. But this is, as far as case law, that some of that has been developed. And I'm sure there's other cases, but that was my first pass at Westlaw. Those were the cases that it came back with. Civil rights in the court, privacy rights have come up. And I don't know if the death penalty has come up yet. I may have not been paying attention if it did, but I'm expecting it to. Anybody else? Well, this court made up. Well, I guess that's it. We've been going for 4 hours. Yeah, but we got through day 2, and that was the goal here. So I really appreciate everybody joining me. Like, subscribe. I appreciate anything you can do to help. Thank you for joining me, Stacy, and the chat. Who's still here? Stacy, are you there's a few. Alexandra, thank you. Thank you so much. Morgan Marie coming in and not giving us a hard time too much today. Thank you very much. But yeah, it was a good conversation in the chat, and that's really, that's really what keeps me going. So appreciate it. We'll resume tomorrow. Get through day 3. We're gonna get through as much as we can. August recess. Congress is in recess. We got to fill the time. I like this. I like doing this. They're out until about Labor Day, so then we can expect to resume some Senate and House of Representatives and their committee hearings. But until then, knowledge is power. Subscribe for more. Thank you so much. Be well, and I'll talk to you soon.